But I'd like to create in item number 42, supplementary 42. But I'll not face this petition.
Huh?
I'd like to withdraw this petition.
Don't with.
With a liberty.
Don't with. Let me pass it.
Lot.
Don't with.
Lot.
See, this court duly understands your predicament also.
Lot.
Don't withdraw.
Lot.
I will dismiss it as premature.
Lot.
But you need some liberties.
With the liberty, correct. That's
so. Not now.
Lot.
Let the matter.
Lot. Take that too.
Because your predicament is in view of the judgments which have been passed. You are not in a position to touch it unless something is not.
Yes.
So that liberty has to be given.
Yes.
So if you withdraw it, you won't get that.
Liberty is required. Liberty.
No, not that. The other liberty
not
for initiation of department.
I
beg to item number 30.
30?
37.
37.
This matter supposed to argue by Mr. P.K. Govardhan, but his mother illness is going to Samadhi his home immediately.
Why the matter has come up for orders? By order? You mentioned it.
Yes, bro.
Then?
His mother
Who? At the request of the learned counsel for the petition, a matter stands adjourned to be listed after the winter vacation. Huh?
Item number 4.
I can't hear you.
Item number 4.
Yes.
Matter may be adjourned for the debtor.
Want to withdraw?
Adjourned for the debtor.
At the request of the learned counsel for the petitioner, matter stands adjourned to be listed after the vacation.
Daily list item number 1 for motion.
You want to withdraw? Why? Don't want to face the dismissal on the reopening. Okay, the learned counsel appearing on behalf of the petitioner. You've got the money?
Yes.
The learned counsel for the petitioner submits that as the petitioner have already received the ex-gratia, the instant writ petition has become infructuous, for which he submits that he has instructions to withdraw the instant writ petition. Accordingly, the instant writ petition therefore stands dismissed on withdrawal.
I'm up. Item number 2.
Please, your lordship, my lord, this contempt petition is for violation of your lordship order dated 26/2023, operative portion as page 11, my lord. There was a direction to conclude a missed case, my lord. Paragraph 6, my lord. Operative portion. In pursuance of this order, my lord, a notice has been issued at annexure to page 12, my lord. Thereafter, hearing has been conducted. Hearing has been concluded, but till date, my lord, no order has been passed, my lord. Annexure to page 12.
When was the order passed?
26/2023.
And where is this notice?
Notice on 9/8/2023.
Then?
Thereafter, hearing has been concluded, my lord.
Hearing concluded when?
Hearing,
Prior to that or before that?
after that, my lord. Because 23/8/2023 hearing was conducted, my lord. On 23/8/2023.
23/8/2023. Hearing concluded.
Concluded, but no order has been passed yet,
Where have you made the statement?
my lord.
And when did you intimate the circle officer about this thing?
My lord, immediately after.
How?
by submitting a copy of the.
Where?
My lord, they have not acknowledged the receipt, but.
No,
in
no.
absence of that, my lord,
Are you saying that the circle officer did not acknowledge the receipt sent by you?
the officer.
File an affidavit. Have you mentioned it that you have sent it and by way of an affidavit, they have not done it? Where is it? Hmm?
My lord, paragraph 8, my lord, page 5, my lord.
Yes. Where?
That after the hearing dated 23/8/2023, the petitioner approached the respondent contender on several occasions.
No, about this order. That you have submitted this order. Because you mentioned about a copy of the notice, everything has been mentioned.
Yes, my lord.
Where have you mentioned that a copy of the order was served? No. Contempt application is not maintained. Do it properly.
Yes. My lord, page 7, paragraph 7, my lord, I have stated that, my lord. Page 5, paragraph 7, my lord. That the petitioner on the basis of the judgment and order dated so
Where is the representation?
filed a representation before the to dispose along with the copy of the order, my lord.
Where?
The respondent contender on the basis of the state representation issued notice to hearing.
Where have you mentioned along with the copy of the order?
That is not mentioned.
Then therefore, the instant contempt application has been filed against the circle officer. Lanka Revenue Circle, alleging willful violation to the order passed by this court on 26/2023 in WPC number 2084/2022. This court had perused the said order dated 26/2023, wherein there was a direction to dispose of the said mutation miss case number 153/2021 as expeditiously as possible after providing an opportunity of hearing to all the parties. Further to that, a perusal of the contempt application does not show that the respondent authority that the order dated 26/2023 passed in WPC number 2084/2022 was served upon the respondent herein. Under such circumstances, a case has therefore not been made out for issuance of a notice upon the respondent. Be that as it may, it is also seen from a perusal of the contempt application that there has been further, that there was a hearing conducted on 23/8/2023. Under such circumstances, this court, without issuance of any contempt, without issuance of notice, would observe that the circle officer having heard the matter to take appropriate steps for disposal of the said mutation proceeding at the earliest.
Deeply obliged.
You serve this copy, then you will get it.
I note it.
May I please, the impugned demand notice by the excise department.
Hmm?
We have impugned a demand notice of the area payment establishment cost by the excise department. And in the morning, I came to know Lordship has already decided that matter in another week. So Lordship will allow me some time to go to the judgment if I can distinguish on the fact.
You have the copy of the judgment?
Not today, I'll show him a copy. I'll take it.
I remember it by heart. Give it to him.
Yes, Lordship.
We'll take it up at 12 o'clock. These matters should not see the next year.
Obliged. May I please, Your Lordship?
Yes, what is this?
But if the petitioner is the sitting lessee of South Salmara, South Salmara ferry service Lordship.
Hmm.
Lordship may kindly come to page number 27, Lordship, and extra 5.
Hmm. Then,
Here, Lordship, the private respondent, Lordship,
hmm.
he was allowed to run one boat
Hmm.
on PLC mode
Bye.
by the executive engineer, Lordship.
Down. There's
Thereafter,
a,
Lordship, may
there's
kindly
a
come to
clash between Panchayat
No.
and
No, Lord.
water resource, water transport department.
No, Lord. Here, Lord, there is no role of Panchayat, Lord. Everything has been done by the water resource department. Lord, kindly come to page number 28 for a moment.
Hmm.
This is the report, Lordship, submitted by the junior engineer, Lordship. May I read it, Lordship?
Of
Very relevant. Of Lordship, inland water.
yes.
With reference to the subject cited above, I have the honor to inform you that due to rapidly decreasing of water level of Brahmaputra River, the operation of Fulbari Dhubri ferry service has been suspended with effect from 20th October 2023, which I have earlier intimated also. It is mentioned here that as the river water dries up, which normally happens during the winter session, the operation of Fulbari Dhubri ferry service remains suspended. Remains suspended till the next spring season. As per the records, it's been continuing in the same way, and it may perhaps continue to be the same, irrespective of any unwanted heavy rainfall. Under such circumstances, the operation of the said ferry service through PLC mode at present is not feasible. Moreover, you are informed that as the water level dried up, the original points of most of the ferry services were changed at present. So, operation of PT service is creating controversies in the Fulbari side against operation of Goff Settle Dhupri South Salmara ferry service. This is me, Lord. Since the Dhupri South Salmara ferry service is present,
What is this PD service?
PD Lord Fulbari Dhupri. This is the name.
So operation of PD service is creating controversies in the Fulbari side against the operation of government. That is okay. Then
That is Lord DSS. That is my ferry service, Lord Dhupri South Salmara. Is presently operating. Since the Dhupri South Salmara ferry service is presently operating from a different location at present, the boat owners of PD ferry service wants to operate from the same point where Dhupri South Salmara ferry service is in operation. As the Fulbari Dhupri ferry service is temporarily suspended with effect from so and so, for smooth operation of DSS ferry service, the operation of PD service, that is Fulbari Dhupri ferry service, should be stopped immediately. Thereafter, also, Lordship, the report of respondent number 5 is flying. Now, Lordship, kindly come to page number 29. Page 29, Lordship. This is written by the junior engineer to the officer in charge of South Salmara police station. With due respect, I have the honor to inform you that Dhupri South Salmara ferry service was settled for the period so and so of rupees 5,55,000 only with Vidut Chandra Roy, who is the petitioner here.
So you are the person who is having Dhubri Salman.
Yes, sir.
So this junior engineer happens to be very fond of you. The junior engineer happens to be very fond of you. Yes, inland.
Now, Lord, this is the
Understood. Okay. Yes.
My lord, it appears that there has been some person who has been unauthorizedly flying in the ferry service. My lord, the junior engineer has communicated to the police station as well. My lord. So the police will have to take action on that.
Police.
My lord, if there is any unauthorized person who is flying on the rivers,
No, the junior engineer of DSS ferry service.
my lord,
Is he your person?
my lord, yes, my lord,
He has informed you.
executive engineer.
Then what have you done?
My lord, I have to take inspection on this. Notice may go.
Yes, madam.
Regarding that, Annexure 7 page 29.
Hmm. You come into the picture because of Annexure 7.
7.
Because the other person, how is he running? Because here, if you see this particular document is Annexure 6. This is the PD ferry service. PD ferry service is done by whom?
My lord, I have to take
By whom?
Lord, that has been suspended. That is not in operation.
Then who is, because then why is it mentioned to stop service?
And because
Ferry service, the operation of PD ferry service should be stopped immediately.
Lord, because of
If
Annexure
it is
5.
suspended, where is there to stop?
Because of Annexure 5.
What
That
is
has
this
been-
Annexure 5?
Annexure 5. Okay. With reference to the subject cited above, it is inform you that the board named the SB Mubarak by
What is
its
BLC mode?
PLC.
What is that BLC?
PLC mode profit, it is day-to-day basis arrangement, Lordship. The board owner has to pay the amount per day system. It is not settled. And Lordship, the report,
Now what do you want?
Lordship, this is a clear violation of Rule 35.
Of
Rule 35 of the Control and Management of Ferry Service 1968. May I please?
Mr. Council will issue notice
my lord.
and I am not going to say anything. I will do only one thing, allow them to do whatever they feel like till next date. You take service by way of dusty upon that person concerned. Then on the reopening, we will close it after getting instructions. Get the final relief. What is the,
May I submit?
during Christmas, what is he going to do?
May I submit?
Yeah.
My period will be expired on 31st of March 2024.
So don't worry.
In
If
that-
this court is taking up this bench, I'll finish it off prior to that. Okay.
And I have to pay Lordship 5,55,000.
To pay.
I'll take instructions, my lord. Of the
You did not say anything since this person was given on 3/8/2023.
He has not been given in my period.
I understand now he's using your ghat.
Yes, Lordship.
So
Dear
these
Lordship,
people,
I don't have even any
so,
objection.
so, kindly listen. Okay, issue notice. Making it returnable on 8th of January 2024. Mrs. S. Udas accepts notice on behalf of respondent number
4, 5,
4, 5,
7, 8.
7, 8, 9. Mr. So-and-so
1, 2, 3, and
appears on behalf of respondent numbers so-and-so appears will
1, 2, 3, and
Udas appears. अरे यहाँ appears for एक. As the respondent numbers 1 to 9 are duly represented extra copies of the petition be served upon them during the course of the day. As regards the respondent number 10, petitioner is directed to take steps during the course of the day by way of registered as well as usual. Further to that, the petitioner is also directed to take steps by way of dusty, routed to the registry of this court and file an affidavit of service on or before the next day. The case of the petitioner herein is that the petitioner is a settlement holder of Dhubri South Salmara Ferry Service for the period 2022 to 2024. It is the further case of the petitioner that the petitioner have been regularly making payment of the due kist amount without any objection from the respondent authorities. Be that as it may, the executive engineer, Inland Water Transport Division, had permitted the respondent number 10,
Yes, sir.
10 to operate the Phulbari Dhubri ferry service through BLC mode by the communication dated 3/8/2023. Full stop. The petitioner at that relevant point of time was not aggrieved by the said permission so granted, taking into account that the ghats which were being operated by the petitioner as well as the respondent number 10 were different. However, with the water, with the water level decreasing, the respondent number 10 is now presently operating from the same ghat with that of the petitioner, and thereby the petitioner is incurring losses. Full stop. To that respect, the petitioner have also enclosed a report being submitted by the junior engineer /D/S/S ferry service, who is also an official of the Inland Water Transport Division, wherein there was a direction where there was a communication issued to the executive engineer Inland Water Transport Division for stopping the operation by the respondent number 10 immediately. However, nothing has been done by the Inland Water Transport Division. Full stop. The petitioner has also lodged an FIR before the officer in charge of South Salmara Police Station against the alleged unauthorized flying of boat by the respondent number 10. However, the said official have also not taken any action. It is under such circumstances the instant petition has been filed. The petitioner herein have sought for an interim relief to the extent that this court should direct the respondent authorities to stop the operation of the respondent number 10. It is the opinion of this court that without giving an opportunity to the respondent number 10, passing of such an interim order would not be in the interest of justice. Be that as it may, this court, however, observes that pending notice, the respondent authorities shall be at liberty to take such action as provided under law.
Obliged.
Highly obliged.
For sake,
The interim order shall be considered on the next return.
On
Obliged.
I picked it.
highly obliged.
Obliged.
Yes, what is this?
This matter relates to
Why do we have a health department counsel in a demarcation case? Yes.
PWD.
Oh, PWD, yes. Tell me, what do you want?
Relates to compensation.
To
for
demarcate access the land
Yeah.
covered by dark number under Iman and to pay adequate compensation for utilizing the land for construction of the RCC bridge on the road of to enter reach in the nature should not be directed. Yes,
My lord,
your land.
My lord?
Your land.
yes, my lord, my personal land.
They are constructing.
Yes, my
Why are you constructing his land?
But at that point, lordship make that means some time to have the instruction.
So don't construct.
No, he's only after the compensation. He wants compensation.
You want compensation of the land.
Because initially in the
Choose
CS,
either of it.
yes.
Yes, my lord, complete.
And if we delay it, delay the construction from your compensation, some part will go for the escalation. Are you willing to pay that? No. Issue notice then. Issue notice making it returnable by how much time? 24th of January.
Lot.
You get your instructions. No affidavit is required. Issue notice making it returnable on 24th of January 2024. Mr. B. Gogo appears on behalf of the respondent number 1,
1, 2, and 4.
2, and 4. Mrs. Yudas appears on behalf of the respondent number 3 and 5. Full stop. As the respondent numbers 1 to 5 are duly represented, extra copies of the writ petition be served upon them during the course of the day. Full stop. The case of the petitioner herein is that petitioner is the owner of a plot of land measuring how much?
1 bigger.
1 biga, 1
bigger,
katha, 6 lesser.
Yes.
Covered by dark number. What? What land is this?
245, my lord, that number.
Where is the patta?
Patta number 126.
Dark number 245 included in patta number 126 of village Dakshin Sitoli under Zonia Moza of Bakbar Revenue Circle. The petitioner along with 5 others are the owners of Cohen. It is the case of the petitioner that the respondent authorities, more particularly the PWD department, is constructing an RCC bridge on the road from Kalapani Bazar to Sitoli Path, bearing package number AS01-268. And in doing so, the petitioner's land have been used without acquiring the same in accordance with law. The respondents shall apprise this court on the next returnable date as to whether the petitioner's land in any manner has been taken for the purpose of construction of the RCC bridge as well as the road. And if so, as to whether any steps have been taken for acquiring of the said land.
Most of it.
Supplementary list at number 21, motion PA.
Yes, what is this?
Section 21B lordship,
Section?
NDPS 21B lordship.
You are inside or outside?
He's inside lordship for 35 days.
35.
35 days.
What is this 21B? What you have done?
21B lordship, the intermediate quantity lordship.
Understood. But what is that?
In between,
Heroin, cocaine, which one?
that is not specified in the FIR as well as in the forwarding report. And
You know? You know that.
No lordship.
You have put the grounds of arrest. What is this?
Here it is the
In presence of a recovered 21 numbers of plastic containers
Yes.
from his pocket of the pant worn by so-and-so, weight of Iman of suspected to
suspected
be
to be
narcotic substance duly seized as per the seizure memo.
Yes.
During investigation, sufficient evidence have been found against him regarding. What is this?
My lord.
What is this type of thing? Suspected of narcotic drugs. This was done when? 1911.
1811.
1811. Till now you don't know. What is it?
No, that has to be sent to my lord, FSL thereafter only, my lord. They can say whether it is heroin. or
Suspected
something.
of what? Something has to be there. Suspected of ganja, suspected of heroin, suspected of something. You don't suspect anything. You say narcotic drugs, which comes with ABCD to everything. Then what is this type of thing? FIR or FIR or forwarding report? Anyways. 21B, you have mentioned it. 21B means intermediate quantity. So
Intermediate
obviously it cannot be heroin.
Mm.
Heroin, what is the commercial? 10, na?
Commercial, 250 grams.
250.
No. Heroin cannot be 250
Heroin
grams.
lordship,
10
Commercial-
grams.
heroin 5 is the small quantity, 250.
No. Heroin can't be 250. 250 is
Commercial.
heroin 250.
Heroin 250 grams. And small quantity is 5 grams.
Small
Small
quantity.
5 gram is small quantity.
And
And 250
intermediate.
gram is commercial quantity.
Heroin,
And above 5 gram, it is intermediate. But below 250 grams.
and quantity weight with the container lot.
Hmm?
With the container 27.02 it is. 21 numbers of container. So it will come under
21 numbers of plastic container.
plastic container. Including the weight of container lot to 27.02.
Then you move the trial court.
Yes, Lordship, the session judge was the special judge
No.
at the initial stage, Lordship, that was rejected. I have made the step.
Yes. Chalo. Without calling for CD, not possible.
Applicant not yet
Okay,
given.
we'll have it on when? On 4th. 4th, you can get it? CD. 4th.
Obliged.
লিখি দিব দেই।
Post 39, arrested on 12/9/23. I take
Hmm?
the lordship to page 19, charted case. The scissor list, your lordship will find page 19 with plastic soap box 338.93 grams and in pouch 109.94 grams.
Hmm.
So it is below commercial quantity, my lord. The rigor of 37 will not come
Why?
because below is 37 because it is
Why they are putting 21C?
21C.
Where is
21
the charge sheet?
charge sheet they have stated 27 is there, madam.
Suspected hearing weighing 354.48.
My lord, they say it is with the box in the scissor list, page 19.
Which was seized. No, they filled, no, soap boxes filled with suspected
Yeah.
weighing to and
In the scissor list, page 19, the soap
we have to
box.
call for the scan copy of the
Follow.
scan copy. We'll have it on from which court?
My lord, here, come to.
Okay, we'll have it on 8th of January. Call for scan copy. To raise the help.
Right.
Why these matters were listed before yesterday and today it has again come? Anyway,
Well, the matter was listed yesterday, but the Honorable Court did not.
did not. Okay. So there is a sign out there. Anyway,
Not,
this is under 448, 366, 511.
At the stage of consideration of that, the accused person defaulted to appear. And
Huh?
that's why, at the stage of consideration of that, the petitioner defaulted to appear before the learned trial court.
Where?
So the session judge, Kamrupani. And that's why my lord NBW was it. And thereafter, the petitioner voluntarily appeared and surrendered before the learned trial court
Hmm.
with a prayer to allow him.
What is his name?
Kosimuddin.
Kosimuddin. He's produced from jail halat. He's remanded back as so and so, paying for bail and is voluntarily surrendered against any plan since he is in jail. So are you going to jump bail if I give you?
No, sir. No, my lord.
Huh?
My lord, two more accused are there. They have not turned up, my lord.
Forget about others. We are concerned with you.
My
So
lord, I will appear, my
regularly,
regular.
where do you stay?
My lord, I am staying in Kamrup district, my lord. At village.
Huh?
Under Saga police station, my lord.
Kamrup district where?
Under Saga police station, my lord. Bhulukabari. Village Bhulukabari. Under Saga. Now Goremari police. Sorry, Saga police.
Chalo. The instant application filed under 439 is filed under section 439 of the Code of Criminal Procedure 1973, praying for bail to the accused, namely so and so. Full stop. It is pertinent to mention herein that the petitioner herein is an accused, is a charge-sheeted accused in Sessions case number 54/2019, pending in the court of the learned Sessions Judge Kamrup at Amingaon. Full stop. As the petitioner did not appear, the petitioner was earlier granted bail. You were granted bail.
Madam.
However,
So charge sheet was absconded. Because he has been shown in a charge sheet, he is shown as absconded at page 12 below.
My lord, after charge sheet, my lord, I appeared on receipt of summons before the learned court below.
so they put you inside.
No, my lord.
Were you at any point of time granted bail earlier? Where is it?
It was granted bail by the learned judicial magistrate first class. On receipt of
Order.
summons, I appeared before the learned judicial magistrate first class 2, and he granted me bail.
Where is
And
that?
then,
Order, copy of the order.
my lord, I have started in paragraph 3, my lord.
Where is it? You have a copy of it?
My lord, thereafter, my lord, the case was committed. All procedure have been concluded in the judicial magistrate first class. There is the bail and copy, etc.
Hmm?
In the charge sheet, he has been shown absconded below.
Paragraph 3. 2. Paragraph 3.
You show this document,
My lord, unless and until the
Mr. Counsel. Show this document. Otherwise, I'll ask for the scan copy. You can show the document today. I'll take it up at 2.
My lord.
Get this order. I'll pass the order in your favor. But if you don't, I can't help you. Because this is a very important document. You should have enclosed it. I'll take it up at 2. Certified copy. Certified copy. Photocopy of the certified copy will also do. You can get it, whatever may be. Try. It is in Kamrup.
My lord.
Yeah, time is there. Find it out. Or 3 o'clock. Get it. Yes, madam. Under what section?
22C of NDPS,
What is that?
arrested on 28/11 commercial purpose and recovered some psychotropic substances suspected, and those are some tablets, but it is not in the notification.
Okay.
Notification of the act.
When?
Kamrup.
Kamrup?
On court, Kamrup, below.
Okay.
On court.
4th January.
Lordship, can it be fifth?
Okay. You want it on 5th?
Please, the Lordship.
Please, your Lordship.
The second bail application, Lordship.
Yes,
Second bail application.
Yes, sir.
but please, your Lordship.
Rejecting this would not be in the right interest.
Yes, Lordship, I next.
Yeah,
Highly-
charge sheet given.
Yes, Lordship, started.
We have to call for the scan copy.
Yes,
Any change in circumstances? No. Why?
I'm not aware.
What?
I'm not aware about the fact.
You are not aware of the fact. Why? You are NCB.
Yes, Your Lordship.
Why you are not aware? Copy was not served.
No copy was served to us.
Then you did not have the time to read it. Too busy. Huh? Or did you say that I'll just show the face to my face to the court? The court would be
No,
happy
Lordship.
enough to call for the scan copy.
Your Lordship.
Then yesterday also the same state of affairs. You appeared yesterday
Yes,
in that matter.
yes.
It is the same state of affairs.
Actually, I was.
Or is it that
The
your
other
senior is not around so just to show your face would it be enough?
I was in the other court. I came running
Running from?
other court.
So you didn't see the file.
I was about to bring the file now. The matter was
Oh.
called.
Okay, scan copy. You have been inside how long?
Lordship, 2 years, 5 months, 10 days,
2 years,
Five.
5 months.
10 days.
What is his name?
Krishna
Krishna
Mishra.
Biswas. Yes, what is your ground? What is your ground?
Earlier bail was rejected by the Honorable Court. Lordship.
Hmm.
Lordship, kindly page number 53, Lordship.
Hmm.
Earlier bail, whatever. Lordship, page number 50, kindly. The land trial court shall expedite the trial of the case if charged are framed by maintaining calendar of hearing, avoiding unnecessary adjournment. The prosecution NCB shall ensure production of all the witnesses on the date to be fixed to prevent delay of disposal of the case. Forward the copy of this order to the land trial court. Lordship, till now, charge was framed on 6/6/2023. Total 11 prosecution witnesses are there, Lordship, where only one prosecution witness were examined till now, Lordship. And the contrapel of 61.56 of spesomoroproximum capsule are recovered, not from me, Lordship, from the Maruti Courier Service, where I annexed the Lordship. 44, page number 44. Only small quantity recovered from me, Lordship, 0.800 gram heroin.
How much?
0.800 gram.
0.800 gram. What is that?
It-
8 milligram.
It shows the 800 gram. 800. That
0 kg.
0 kg,
No.
800 gram.
You should say that 0.800 gram means 0.8 kg. Okay, we do one thing. Call for the scan copy. 19th January.
Obliged. Made to the court.
Hmm.
The matter pertains to minus NDPS commercial quantity. Scan copy of the LCR call for. Certificate.
Commercial.
Yes, ma'am. Certificate.
Charge sheeted.
Yes, 22.
19th.
Highly of. May I repeat, Lordship? Lordship, 439 application, Lordship. 71 is behind the bar. Lordship. FIR is page 8, Lordship.
457, 376, 3.
Yes, Lordship. Of course, there, Lordship. So 71 is behind the bar. Lordship. With page 18, Lordship, 1 point, Lordship. Page 18. All right, take.
Call for a CD. And not only
notice-
that, here
notice.
you have to also intimate to the police.
Madam.
Lordship,
Let him take steps.
Page 18, Lordship.
He has to take steps, my lord. We'll furnish to OC.
To লেখক দে, order to লেখক.
Can you page 18?
This is an application under 439 of the Code of Criminal Procedure 1973 for release on bail of the petitioner who was arrested on 13/10/2023 in connection with Moran police case number 99/2023 registered under section 457/376(3) of the Indian Penal Code,
Read it.
read with section 6 of the POSCO Act. Full stop. The PP is directed to produce the CD on 10th of
8-1.
Yeah.
8 January.
here. Another thing is, let it be on 10.
My Lordship, 6 can be 90 days to over.
Huh?
On 11, Lordship, 90 days to over. And 6, Lordship. Done.
6th is Saturday.
Then 8, Lordship.
8 on 8th of January 2024. Full stop. Further to that, the petitioner is directed to serve a copy of two copies of the instant petition upon the PP during the course of the day. The petitioner shall also provide a soft copy of the petition to the PP. Full stop. On receipt of the same, the PP shall forward one copy of the one hard copy of the petition along with the soft copy, email the soft copy of the petition to the officer in charge of Moran police station, so that the said officer in charge shall to the investigating officer, of Moran PS case number 99/2023, so that a copy of the said petition of the instant petition be served upon the respondent number 2.
A copy of this order may be furnished along. A copy of this order may be
A copy of
And
this order be also furnished
so that I can communicate.
to the PP for additional PP
Additional.
for due compliance. Put his name, huh?
Offense under section 376. It may be called for. He was arrested on 5/11. Original FIR page 12.
376. Okay, call for city. When? Konapur is where?
On 5th or
Fifth.
4th.
Call for city, huh?
Application under section 50 already started behind the bar 9 March.
Does she did?
Yes, to
Okay, we call for a scan copy. Yeah. 19th. We shall take step with the author can call for the scan copy of pending in the court. The registry shall appropriately shall take appropriate step for requisitioning of the list the matter online.
May I please, Lordship?
No, yes, tell me, what is it?
My Lord, the petitioner, my Lord, was fully arrested. my Lord,
120B, 467, 468, 447, 427.
Can you see the allegation, my Lord, with the FIR? What happened, my Lord?
Where?
My Lord, page 11, 12, man.
When? Since when you are here? Okay, 312.
Yes, ma'am. Please bear.
20 days have been done.
My lord, allegation, my lord,
Where is the FIR?
FIR case 12, ma'am.
There for stone arrest of the person and took badly shot.
Petitioner is an advocate, my lord. My lord, alleged date of incident, my lord.
You are referring to page 14?
My lord, page 12, ma'am.
Page 12.
Page 12.
Oh, land grabbing.
Land grabbing, my lord, and between the parties, the petitioner is an advocate, my lord. On behalf of the my lord, accused side, my lord, that is why his name has been implicated. And my lord, in this case, my lord, he was already granted bail, my lord, yesterday, my lord. After 173 days, my lord, this affair has been lost, my lord. And after 173 days, my delay, my lord. Because as alleged, my lord, 11/6/2023, my lord, occurrence was took place, and my lord, affair, my lord, 29/11/2020. When, my lord, I arrested in another case, my lord. And in that case, my lord, I have been already released on bail, my lord, yesterday. So soon arrested, my lord, and nothing is there, my lord, in this affair against me. Only, my lord,
Who are the petitioner?
my lord, petitioner, my lord, Manuel Haq is the advocate.
What is the advocate doing out there?
No, my lord. Actually, my lord, in this case, my lord, nothing is there against. In my lord,
Something wrong. Has his bar council license been cancelled?
in main case, my lord, he has already, my lord, it is not yet.
Main case.
Yes, my lord. In the
Where?
time branch case, my lord, yesterday, my lord, PA number 4639. My lord, order has not been uploaded, my lord. That is why I could not get.
Without CD.
Yes, ma'am. Because, my lord, another accused, my lord, he also has been granted bail, ma'am. In that case, my lord, that is why, my that was, my lord. I have that order, my lord. But yesterday, my lord, this person also has been granted bail. And in this case, my lord, nothing, my lord, kindly see the affair, my lord. Because, my lord, in that case, my lord, I was arrested. That is why my name has been implicated in this case.
Hmm.
Kindly see the, my lord, page 13, my lord, last para, my lord, that alleged that, my lord, I have been, my lord, arrested in time trans case, my lord. That is why my name has been incorporated in this affair. Nothing. In that case, my lord, I have been already granted.
Okay. Condition deploy bail.
My objection may be recorded.
Huh?
My objection may be recorded.
Is there to object?
In other cases, I did not make this.
Other cases I have not given any. This is the sad part out here that I have not been able to give a single bail. All NDPS matters and all. Bail. 50,000.
I love that. I love that.
Hey, PP objection আছে will লিখি দিব দেই. Yes.
Lordship, the 21A lordship, the small quantity lordship, he is the arrested on 1 year,
Level information source.
1 year 18 days. First one. 29 is 29 is 21A to daily good. 21A daily good. Demand quantity, demand quantity.
It's small quantity.
Small quantity, no recovery lordship, today is 1 year 18 days.
Huh?
Behind the back. 1 year 18 days. Subsidy has not submitted their lord. And the punishment is 1 year. Punishment is 1 year.
Huh?
Punishment is 1 year.
Punishment is 1 year.
1 year.
And you have already been behind bars for 1 year.
1 year 18 days. No, section 29 is there. Section 29 is there.
Huh?
Section 29 of the NDPS also will not.
Abatement.
Abatement is the one. Abatement, 1 year. Anyway, will not.
Section 29. Section 29 is what?
Abatement.
In this 37 needs to be followed. No, no,
Abatement will
no. I don't
not,
think.
not commercial. If not commercial quantity will not.
No recovery from my position, Lordship. Other acres. Recovery from the other acres, Lordship. Default well, Lordship, the no subsidy has submitted till there.
29 is not
That
there.
embargo is only in respect of commercial quantity.
Huh?
Only in respect of commercial quantity.
Okay. And what do you do? Sell drugs.
But
What do you do otherwise?
Then well,
Huh? What do you do?
Lordship.
What is your source of living?
He is the heavy still the package person.
Habitual drug addict.
Lord.
So then he is better inside.
Punishment in 1 year, Lordship, already.
There's no punishment, but I think he is yeah, you go to rehabilitation here. What do you say?
Then well, Lordship, his family is here.
Now, what do you do? Tell me.
কি করা চাকরি করে না বিজনেস করে কি করা
No, labor.
Huh?
Daily labor. Lord. Sometimes that's the thing.
Another thing, tell me, how can Akash Ali be the cousin brother of Ojit Boro? Huh? You have not seen that.
Lordship, typical mistake, Lordship. Actually,
What is it?
cut and paste
How can I do it on the basis of an affidavit filed by somebody else? Means obviously he may very well say next friend or whatever, but you have made a false statement on here. He's my cousin brother.
he is the friend, Lordship. He is the friend, Lord.
Is that?
Friend, Lord. He is the rented house, the attached the petition.
How can I help you? These are apparently a false affidavit. So why shouldn't I initiate 40 proceedings against this fellow Akash Ali for making a false statement?
Lordship, I correct. Lordship,
Huh?
typical mistake.
And who is the person who has identified? And who is the filing counsel? We take action against the filing counsel. Who is Nurjaman Ahmed? You.
I am.
Okay. We have you here itself. You know it is false.
Lordship,
You
actually,
prepared a petition.
Right.
You made a false thing. You fail because if you say that it is a, you say he's a, now you are saying that he's a friend.
Lordship, actually, typical mistake, Lordship.
There is no typical. We impose some sanctions upon you, making a false statement. Huh? You want to also apply for bail. Huh? This court normally doesn't take criminal matters, but then also writ matters. In these type of matters, it is a high case. It's a very important case for either suspending the license of the lawyer. So your license should not be suspended. Why? Tell me. Give me a good reason. It is on the face. On the face of it, it is wrong.
Typical mistake, Lordship, copy paste, Lordship.
Copy paste.
Lordship, the.
So you are saying this affidavit is on the
No,
basis of
no,
copy paste.
Lordship, the actually the friend, Lordship, the typical.
What actually the friend?
Lordship.
I'm dismissing it on this ground. File it properly. Withdraw it. File it properly. You can't do this in this manner. And I'm suspending your license for 2 months. So it's some other lawyer can file it.
But
Lordship, so we do this petition
Huh?
highly praised, Lordship.
Yes. The learned counsel appearing on behalf of the petitioner submits that there has been some inadvertent mistake in the bail application for which he would like to withdraw the instant application and file afresh. So, taking into account the above, the instant bail application stands rejected on withdrawal. Full stop. Be that as it may, the petitioner herein would be at liberty to refile by removing those defects. Next time, don't do it.
Lordship.
May I please, Your Honor?
Hmm.
Lordship 438 application, Lordship.
Oh, at
Section-
last something good.
Sections added are 376 along with section 4 of POCTO. Here, Lordship, the incident happened 3 years back. Now, this FIR has been filed in 2023 regarding the incident happened in the year 2020.
Where is it?
Lordship may kindly peruse page number 11. It is type copy. Translated type copy of the FIR. And in vernacular, Lordship is at page number 14.
We grant him interim.
Yes, Lordship.
Interim granted. And do one thing, when can you produce the case diary?
However,
When?
Since your lordship is granting interim 8 or 9.
Okay, we have it on 10.
oblige.
On 10. What do you do?
Lordship, I'm a student. Lordship may kindly peruse the last annex, page number 16. And I'm a graduate boy, Lordship. This is my
Graduate is
Must be.
nowadays the minimum qualification. Even for grade 4, we require graduates. Yes. Hello. Bail to deliver. Interim. You are going to appear on 29
oblige.
before the officer in charge.
Oblige, my
Huh?
oblige.
And 15,000.
Deeply obliged, my
33,
তাতে এটা line লিখিব, they have perused the FIR, and having seen that the FIR has been lodged after a delay of more than 3 years. This court finds that this is a fit case for grant of interim plea. Yes,
May I please, Your Lordship? Page number 16 is the FIR, Your Lordship. We are other family member, Your Lordship. Main accused is on Riazul Haq, Your Lordship.
Huh?
Main accused on Riazul Haq.
And
these
you
three
are?
persons are family member of state Riazul Haq. That could be page number 9, Your Lordship.
Who are the other persons? Anwar Ali,
Father of
Ikim
Riazul, Your
Ali.
Lordship. Ikim
Okay.
Ali also. Brother of state main accused Riazul Ali. Zohirun baby is mother of main accused.
And what? And till date you have not been arrested.
Allegation is only 376 and 123. There is no
So they have not
Section of-
arrested you.
assault, Your Lordship.
And you have been hiding.
This whole case, Your Lordship,
For
this
2
affair
months
was-
you have been hiding.
affair was filed on 2nd October, Your Lordship, registered on 7th, Your Lordship, after 5 days. So, we filed a complaint before the SP, Your Lordship.
It
Then
was
we FIR
registered when? 710.
710.
Understood. But
Silent
from
second-
710 also, we have more than 2 months. Why you have not been arrested? Good. And if they have not arrested, why will they arrest you now?
Please
Huh?
visit our house, Your Lordship.
Or you advised him that better file a bail application? You advised.
Right.
Chalo. The interim to deliver. We have it on which police station?
Gauripur. Gauripur.
Gauri. You can have it on 18th.
Right.
18th, and you appear on all of you appear on 2nd of January before the investigating officer for recording the statements.
Public.
And that Lekiri was that from a perusal we had, the allegation of 376 is not under of the penal code is not made out against the petitioner. It's prima facie not made out against the petitioner, and as such, this court is of the clear interim subject. 15,000 each.
34.
Yes, what section?
My lord, FRS page 16, kindly see the FRS page 16. Actually, the informant purchased a plot of land measuring 1 katha.
Oh, the same one.
Same.
It's a person who was inside. I put him out. Now, who is the other one? Simon Boro.
Simon Boro.
His name is not here.
FR He's not FR
Then they could find out later on. And since when you are inside?
No, this is anticipated.
Anticipatory. Okay.
Well, I will produce the case hearing. I will produce the case hearing.
Now we give him an interim. Record his statement.
And my lord, one line objection, my objection may be because this is a very sensational case.
Objection detail. Objection display. When are you producing the case diary? 18.
My lord.
18.
18, yes.
18.
Yes.
18 the case diary go interim 50,000.
My lord, my humble petition is they kindly call for the report regarding the disputed land. Whether this land is fall under tag number 100 or
Mr. Counsel, for that you file writ. Now for that bail, I have asked them to call for a CD. I'm giving you an interim. Yeah. Go and appear before the investigating officer on 2nd of January.
my objection.
Yes, objection. As vociferously object.
35.
Hello. 438 application, madam. Under section 431, 386 and 50. Hello.
341, 386, 506. What have you done?
Extortion. Madam, madam, other accused madam has already granted bail. Page 12.
What did you extort?
Two
What is your
accused
name?
madam.
Joint
Bodul and Avijit Kanga.
you respect that.
Yeah, Avijit Kanga has already granted bail.
Okay, we give you an interim. Surety 33,000. And you appear. When can you produce the CD? 18,
CD
19, 18,
18.
18. You appear on 2nd for the investigating of 33,000. Surety.
Diploma.
36.
Hmm.
438 bill application under section 379, 411 and 34 IPC and cattle preservation act.
Cattle. Interim. When? When?
This is from
Which police station?
Punthana, Khetri.
Khetri. Where can you live? Let it be on 22nd.
My lord.
22nd, you appear on 4th. Interim 25,000.
41.
41 here, my lord, in this case, charge sheet has been submitted. The charge sheet number is 143.
Yeah. Very. That's it submitted. Now, therefore, we don't see the person concerned. We were fighting a tooth and nail on the last day. What is his name? Mr. N. Hassan. Where is he? What is the number of the charge sheet?
143/23, dated 30/9/23.
You do one thing. Give this link, video link to that particular investigating officer. I'll hear him in the court. I've asked him to be present with the charge case diary here today. Otherwise, in fact, under such this court directs the investigating officer of Laluk police station to be present in the court at so and so at 10:15 along with the case diary.
Today, my lord. Sorry, I do not know. I have not seen the.
Mr. B. Sharma was there, your additional.
My lord, we have received one WhatsApp message. Through WhatsApp message, we have received this.
Ask him to be there. We'll share the video link. We'll take it up at 2.
Yes, yes.
Okay? Because
One
he
thing,
is also to be taught a lesson. Don't you think?
My lord, what is the name of that? My lord?
Huh?
One
Laluk police station.
Kuldeep Gogoi. My lord, perhaps he has also sent one medical document. Perhaps he is investigating officer. This is regarding, this is the message, and my lord, second one is with a medical document. Perhaps he is unaware.
Sorry, Lordship.
In this case, charge sheet has been submitted. So you go there. Nothing to. Pursuant to the order dated 2012-2000, this is an application on the 438 of the CRPC filed by the applicant, namely Rakibul Islam, for grant of pre-arrest bail in connection with Laluk Police Station case number 122/2023, registered under section 4/12 of the POSCO Act, read with section 67 bracket A of the Information Technology Act. This court, by an order dated 2012-2023, had directed the investigating officer of Laluk Police Station case number 122/2023 to be present in the court today. Mr. So-and-so, the learned additional PP, has today forwarded, placed before this court a WT message issued. WT message to the effect that the investigating officer of the said of Laluk Police Station case number 122/2023 is suffering from cold, cough, and loose motion. And as such, upon doctor's advice, he could not attend the court today. Be that as it may, it has also been mentioned that to the said effect, a certificate, medical certificate issued by the National Health doctor of the National Health Mission was also produced. So, it be that as it may, it is also mentioned that in respect to the instant case, in respect to Laluk Police Station case number 122/2023, charge sheet number 122/2023, and charge sheet number 143/2023 was submitted on 13/9/2023. Before whom?
I have not seen. This is it.
Laluk, it will be which one? Lakhimpur? Lakhimpur. Before the Chief Judicial Magistrate of the law.
Before the Lordship, special judge Pokso. Special judge Pokso.
Before the Special Judge Pokso, Lakhimpur. Taking into account the above, this court is not inclined to entertain the instant proceedings, instant application for pre-arrest bail and full stop. However, the petitioner herein would be at liberty to approach the learned court below, who shall consider the petitioner's application in accordance with the provision with law.
my lord, please, that personal appearance may be discussed.
The
Earlier-
personal appearance of the investigating officer in view of the above facts stands dispensed.
Keep your place.
Yes.
According to the judgment of the part of child or that specifically we stated we have made the payment. They verify the payment that we have made or not. Because we have stated as our instruction that they have paid the amount. Paragraph 13, we have stated that we have paid them. If they verify if they have paid it, we have no case.
We'll verify that, Lordship, whether the judgment is clear.
Judgment is clear. I've
Judgment is
understood
completely
that,
clear.
otherwise there is no case. We have not paid. Not state.
No, this number 3, the wage. The petitioner would be at liberty to place such materials before the Commissioner of Excise to show as regards the amount the petitioners have paid as well as the observation and findings of the subsidy and giving such verification. The petitioner have already paid the amount in terms with the demands were made in custody of funds, so then such case rate shall not that the petitioners have already paid that they would not be liable to pay any extra.
With that only,
So that is already there.
That is already.
that is what
Herein are liable to pay the establishment charges in terms with clause 9 of the so the payment of ad valorem excise duty as well. The respondents are more particularly the Commission of Excise directed to take a definitive decision in respect to the complete dead stock lying in the warehouses in a period of 2 months. You have that stock.
that instruction I do not have with the day stock. The transitional stock that we have paid the ad valorem as well as back that.
Okay.
With that, Lordship, with
And well, Mr. Gogoi, there is the other matter na, on the question of dead stock.
Yes, Lord. Pending.
When it is coming in, I picked the date in that matter. So that is a very important question on whether the dead stock, yes, for the purpose of VAT, it may not be. But the moment you bring it from there, the import is already done. So under such circle, whether it is destroyed or not, the liability will be there.
The matter is pending about.
But that is a very important question. The instant repetition is taken up for disposal at the motion stage, taking into account that the issues involved in the instant repetition is duly covered by the judgment of, is this not reported till now? Bills over. It that will take it up. The incident with petition is taken up for disposal at the motion stage, taking into account that the issue involved in the incident with petition is duly covered by judgment of the court rendered in the case of MS Barak Warehouse Private Limited and another versus the state of Assam and two others. The bracket of WPC number 4575/2021 rendered on
9/5 2020.
9/5/2023. The facts so involved in the instant petition is that the petitioner herein which is a company incorporated under the provisions of our Companies Act 1956. Are you still in the business?
Yes.
Was engaged as a bonded warehouse in terms with the Assam Excise, Assam Bonded Warehouse Rules 19. What is that? That book, na? Excise or book, na? That in 1953 or something, na?
Yes, Lord, it is not here.
Anyway, Assam Excise Bonded Warehouse Rules so and so. Ikon নহয় ইয়াৰ আগৰ এম সিং বিষ্ণুৰ এখন কিতাপ However, prior to coming into effect of the Assam Excise Act 2016, for short the Act of 2016 with effect from 1/9/2016, an issue arose in view of the change in the status of the bonded warehouse in view as it was defined in terms with the Act of 2016. This court finds it relevant to take note of that as per the Assam Excise Rules 2016, Assam Excise Act is of 2010.
Excise Act 2000 and Excise Rule
Of
2016.
2000, huh? Aru Assam Excise Act on whole Act of 2010. Aru, yeah.
Act of 2000.
Exam finds it relevant to take note of that in terms with the Assam Excise Rules 2016, for short the rules of 2016, the term bonded warehouse was defined in Rule 1 capital A Roman 16 to mean the premises or any part of the premises within a manufacturing and or within a canteen, store, depot, warehouse approved and licensed for deposit or storage of spirit on which the duty had not been paid. On the other hand, Rule 1 capital A bracket Roman 17 defines wholesale warehouses to mean those premises or any part of the premises approved and licensed for deposit or storage of spirit on which duty / levy has been paid and from where Indian-made foreign liquor may be supplied by wholesale. Full stop. In view of the change of the definition of bonded warehouse in terms with the rules of 2016, there was a requirement that the said bonded warehouse should be situated within the manufacturing. Full stop. However, as the petitioner's bonded warehouse was not situated within the manufacturing, the petitioner's bonded warehouse came within the ambit of the definition of wholesale warehouses. Now, taking into account the said change in the definition, the petitioner's business from bonded warehouse to wholesale warehouses. An important issue arose inasmuch as in bonded warehouse, the Indian-made foreign liquor were stored or deposited without payment of the duty, whereas in wholesale warehouse, the deposit or storage of IMFL had to be with the payment of duty or oblique levy. In view of the said changes, which was going to be effected with effect from 1/9/2016, the governor of Assam passed an order on 29/8/2016. A perusal of the said order reflects that a joint team was constituted as per the said order, who shall take stock of all such transitional taxable underbound stock of liquor oblique spirit in the erstwhile bonded warehouse, bracket now wholesale warehouse licenses, bracket closed, as on the date preceding the date of coming into effect of the Act of 2010 and the rules of 2016, including the stock in transit, comma, the value of such stock as per the books of account, and were required to calculate and record the government levies involved on such stock, comma, including the ad valorem levy and VAT as per the rules of 2016 and the VAT and the Assam VAT Act of 2003 as amended. In the said order, more particularly at clause 9, it was mentioned that the excise establishment posted at the erstwhile bonded warehouse, bracket now wholesale warehouse licenses, bracket close, shall not be withdrawn till the entire amount of the area, ad valorem levy, and VAT on the transitional taxable underbound stock of liquor, including the stock in transit, is deposited, and the licensee concerned shall be liable to reimburse to the government the salary, etc., of such excise establishment till they are withdrawn by the government on a no due certificate issued by the concerned superintendent of excise or the deputy superintendent of excise and the concerned superintendent of taxes. Full stop. It is on the basis of the clause 9, an imposition of 49 lakhs 90,710 have been demanded by the respondent number 3 for the period from September 2017 to October 2022, which is the subject matter of challenge in the instant proceedings. This court had in the judgment rendered in the case of Barak Warehouses Private Limited Supra held that the petitioners therein, were also similarly situated with the petitioner herein, would be liable to pay the establishment charges in terms with clause 9 of the order dated 29/8/2016 till payment of the ad valorem excise duty, as well as the VAT on the basis of the orders passed by the authorities in terms with clause 3 of the office order dated 29/8/2016. Further, the learned counsel appearing on behalf of the petitioner submits that the petitioners have duly paid the establishment charges, and also there is no dues in respect to the excise duty as well as VAT. And as such, the imposition made by the impugned notice dated 2022 was contrary to the order dated 29/8/2016. This aspect of the matter, however, cannot be verified by this court as to whether the petitioner had paid the said amount or not. However, this court can very well direct the respondent authorities to verify the said aspect of the matter. Accordingly, taking into account the judgment passed by this court in Barak MS Barak Warehouse Private Limited Supra, this court disposes of the instant writ petition, directing the respondent authority with the following directions and observations. Number one, the petitioners herein would be liable to pay the establishment charges in terms with the order dated 29/8/2016, provided the petitioners have paid the excise duty and the VAT. Now, where is the question of VAT now? This is for the earlier period.
That is for the period.
Now, how they are putting the VAT now? There is no VAT now.
There's only establishment charge.
Huh?
Only the establishment.
Only the establishment charge.
No, establishment charges done under what provision?
They have not referred anything to the notice.
Huh?
The notice. Annexure 2.
No, how with effect from 17 to October 2022, how can you have VAT? Huh, Mr. Gogoi? Where is the question of this period? Their establishment charges will be there, definitely.
Yes, Lord.
Only in respect to the excise duty of those goods. Isn't it? Those goods. And also the VAT in respect to those goods. It can't be for these fresh goods.
Fresh goods, yeah.
Because now the VAT is not there.
The VAT is not there.
Then how can I dispose of in this manner? Not possible. I think this is a case for issuance of notice. Because here the question is, where is the question of VAT? Because the period, the order has to be made very clear. How can it be from September 2017 to October 2022 unless the VAT has not been paid? Okay, we can do like this. Just see last line to लिख ले. Establishing. Have not. VAT. And VAT. In respect to those goods, which come within the ambit of the transitional taxable underborn stock of liquor, including stock in transit, next. This code further directs, further grants the liberty to the petitioner to produce before the respondent authorities such documents showing that the petitioner have duly paid the excise duty and VAT in respect to those transitional taxable under bond stock of liquor, including stock in transit. And there has been due certification to that effect by the concerned superintendent of excise or deputy superintendent of excise and the concerned superintendent of taxes. In the eventuality, the petitioner is able to show the same. The responding authorities shall duly consider the same and take further steps as is required in terms with clause 9 of the order dated 29/8/2016. This court, though, have not set aside the communication demand dated 2012-2022, but makes the said demand, but stays the said demand for a period of 45 days from today, thereby enabling the petitioner to produce such documents, and on the basis of such documents being produced, the said demand would be raised. The said demand would be, the demand would be made, and appropriate demands would be made. Before parting with the record, this court, however, observes that from a perusal of the communication or demand dated 2012-2022, there is no mention as to how the said imposition of establishment charge has been made, more particularly with effect from September 2017 to October 2022. It is expected that when such a demand is made, the responding authorities ought to have made it more clear in the said demand as regards the aspect on which the demand was made. With above the petition stands.
That Assam bonded that 1965 a lot.
65. Now,
65.
Assam bonded warehouse rules.
Warehouse rules 1960.
Yeah, please, Your Honor.
Hmm. Why is your impleadment the party petition is bigger than the writ petition and heavier?
Because Your Worship, I have filed frequently judgment, Your Worship.
Why do you need judgments for impleadment?
Not judgment in between party, there was a case.
Huh?
In fact, Your Worship, there was earlier case.
Huh?
That judgment have anything.
Who are you? You are the petitioner?
I am the Your Worship applicant in this case. Seeking impleadment. Here in Your Worship, the NOP was cancelled by the
Yes,
authority.
yes. You are objecting?
No, my lord, I have no objection.
Then whom do you want to make parties? Applicant number 1, 2, and 3.
Your Worship, 1 and 2, Your Lord.
Huh?
Guru Nanak Singh,
1 and
Article
2.
9.
Why do you want to make them parties?
Your Worship,
Why?
Your Lordship, they are the legal heads of 39. Chapter 39.
Dr. 39 Singh.
Ah.
Then
39 Singh, Iqbal Kaur, and Gurubachan Kaur. They are the sisters and brothers.
then
And Your Lordship, he sought a NOK
Ah.
in respect of Iqbal Kaur, who died actually.
Jairaj Vikram Singh.
Yes, Your Lord.
What is he asking for?
Projected himself as a
What
adopted
is he
son of-
asking for? Stay of the writ in the nature should not be issued to set aside and quash the order dated demand issued by the respondent number 2, whereby and wherein the next of the case was issued to the a retainer should not be issued for the directing the respondent. Where's that order? Who are you?
Lordship, I'm projecting myself as the adopted son, my lord, of Iqbal Kaur, my lord, and they says that I have
Of
this my lord Iqbal Kaur, my lord.
Iqbal Kaur, how does he come into picture again? Jairaj Vikram Singh is the adopted son of whom?
They are projecting that they are the adopted son of Iqbal Kaur.
Of
Iqbal Kaur.
Iqbal Kaur.
Kaur.
And you are the?
I'm the sons of 39.
How is 39 Singh connected with it?
39 Singh, Iqbal Kaur, and Gurubachan Kaur, they are the sister and brother. On sister.
And he is the?
He is projecting himself as a adopted
And
son
it is on the basis of your complaint this
of
the FI was the next of kin certificate was cancelled. The instant application has been filed by the applicant. Who seeking impleadment as respondents in the accompanying writ petition. It is the case of the applicants herein that they are the sons of late Dr. Thir Narayan Singh, who was the brother of Iqbal Kaur,
Iqbal Kaur.
of Iqbal Kaur, late Iqbal Kaur. And it is on their complaint, the next of kin certificate dated 2/8/2014 issued in favor of the petitioner was cancelled by the order dated 8/11/2021. So taking into account the above, this court is of the opinion that applicants herein are necessary parties to the accompanying writ petition. And without their presence, the writ petition cannot be effectually adjudicated upon. Accordingly, this court therefore impleads the respondent number, the applicants herein as the respondent number 3 and 4 to the accompanying writ petition. Full stop. The learned counsel appearing on behalf of the petitioner is directed to file a memo of parties showing the names of the applicants as the respondent number 3 and 4 to the directed to file a memo of parties before the registry of this court by 4th of January 2024. On the basis of the said memo of parties so filed, the registry shall make necessary correction of in the cause title of the writ petition accompanying writ petition and upload the same in the CIS. With the above, the instant application therefore stands disposed of. You have got the copy of the writ petition?
Your lordship,
You have it?
I have.
Mr. N. N. Jha, the learned counsel appearing on behalf of the newly impleaded respondent numbers 3 and 4 submits that he has copies of the writ petition and he would like to file affidavit in opposition, for which he seeks an accommodation for a period of 3 weeks. To list the matter again on 19th of January 2024 for admission. The affidavit be filed by 12th of January. The petitioner shall, if so advised, would be at liberty to file their reply.
Number 8.
Lordship, I have received instruction regarding this matter.
Oh, that contractors,
Lordship,
that tractors.
Lordship,
Now those tractors have already been given.
Lordship,
Now the question is there any other scheme?
Lordship. In my instruction second para, Lordship, there is a scheme in which 50% subsidy was given if the petitioner is interested, then the petitioner may be accommodated as per my instruction. If he fulfills the terms and conditions of the scheme.
So as per you, there is a provision of giving 50% or 2.5 lakh, whichever is the lower, provided it is selected by the district level selection committee. Yes, this is the instruction.
Yes, but I have no objection. If the petitioner will provide by that description.
Huh?
If the petitioner will provide the tractor, your lordship, that give me a thought, then I have no.
They don't provide tractors. They only don't provide.
Lord.
You provide tractors.
Lordship,
Where is it?
provide tractor, but 50% subsidy, then they have
There is
to
a
pay.
provision for financial assistance government subsidy of 50% or rupees 2.5 lakh, whichever is less. So either they will give you at 50% or 2.5 lakhs,
for the
whichever
tractor.
is less. You're happy with that?
FP means in earlier one it was 75 subsidy.
Lordship, this previous scheme is not longer exist. Lordship. Only this scheme is exist.
If the petitioner will accommodate with that script, then I have no objection.
Huh?
If petitioner will be provided that is benefit of that script, then I have no
You
objection.
have to apply,
No, definitely. You have
and
to-
the district selection committee will duty take note of. I can only pass an order that when you apply, the district selection committee shall duly consider your.
consider it,
I think that is the only way at the end of the year. This court, by an order dated 12/6/2023, sought for instructions from the Standing Council of the Agriculture Department as to whether there is any scheme for providing tractors to self-help groups or for providing financial assistance to self-help groups to purchase tractors. Mrs. G. Bora, the learned Standing Council of the Agricultural Department, have produced an instruction issued by the Director of Agriculture Assam dated 21/12/2023. In the said instructions, it has been mentioned that there is a provision for financial assistance bracket government subsidy bracket close of 50% or rupees 2.5 lakh, whichever is less, for procurement of tractors bracket 20 to 40 P.T.O. HP bracket close by selected individual farmer or group of farmers under the component number 3 of inverted comma submission of agricultural mechanism inverted comma close bracket open CCS dash SMAM bracket close for the year 2023-24. As per the said guidelines, beneficiary is selected by the district level selection committee bracket DLSC bracket close chaired by the respective deputy commissioner, district commissioner. The said instruction is kept on record and marked with the letter X. Mr. Your name?
A.M. Khan.
A.M. Khan, the learned counsel appearing on behalf of the petitioner, submit that taking into account the subsequent developments, the petitioner would like to avail the said scheme by filing application before the whom?
I did, as per
Before
that-
the district commissioner, which one?
As per that,
You are which district?
I am from Golpara district.
The Gwalpara. Before the district commissioner Gwalpara for evading the said subsidy. He, however, submits that a direction may be given to the said district commissioner Gwalpara to duly consider the application of the petitioner, who's taking into account the above and taking into account the above submission and further that there is a subsidy, there is a scheme which provides for financial assistance as stated here in above. This court grants the liberty to the petitioners herein to apply before the district commissioner Gwalpara for availing the said benefit. And in the circumstance the petitioners apply, the district commissioner Gwalpara shall duly consider such application in accordance with the guidelines of the said scheme. With the above, the instant petition therefore stands disposed.
All right.
I,
May it be.
Yes, after vacation, winter vacation, we are just before winter vacation. Tell me. This was the last day of
Yes,
Pooja, and today is the last day of winter. But tell me.
Matter pertains to non-payment of granted aid.
Grantil,
Aid. Case number 12. Already. granting aid of rupees 10 lakh.
Oh, yes, that day I was supposed to dismiss, so it has come now.
Yes.
I remember. They may like or they may not like. These are the words I use.
My lord, they have already accepted the deducted amount, my lord. Receipt has been signed by the petitioner, my lord. 2 lakh 3,000.
Where is that?
660. An extra 2 of my affidavit, my lord. Running page
Remember
33, my lord.
nothing to that. Except two
This is
of them.
totally afterthought, my lord. Page 33, my lord. An extra 2.
Yes. Received so and so as granting aid from the Office of the Development Commission of so and so. So what else do you want?
Now they are raising question, my lord. Wrongly.
Lordship, actually, what happened, they have taken, granted aid was rupees 10 lakh, or out of that amount, 5 lakh released earlier, Lordship. Remaining 5 lakh was supposed to refunded. What happened, Lordship, the duration of the project was for 6 months. At the last month, Lordship, the present secretary of the society was not the secretary then, Lordship, when the project was going. At the last month, only for 22 days, he has become the secretary as the earlier committee has resigned, Lord. For 22 days, they cannot appoint a new designer, Lord. According to the rule, Lordship, no designer from the society can be engaged as designer. But for 22 days, since the earlier committee has resigned, the present secretary has become the secretary of the organization. And for 22 days, no society can appoint a designer, Lordship. But it is a process. Someone has to select it, then appointed as designer. So for 22 days, they have deducted the entire designer fees. If your Lordship come to page number 11, page number 12 of the writ petition, Lordship, first column, Lordship, designer fee including TA and DA is 2,50,000.
Where page?
Page 12, Lordship. First column, Lordship. A designer fee including TA 2,50,000. If your Lordship divide this by 6, 1 month designer fee will be around 41,666. Is this amount they deduct, Lordship? The organization has no issue, Lordship. But they have replied in their affidavit in opposition that the designer amount cannot be fractionated. And because of that, they have deducted the entire designer fees for 2,50,000 for the entire duration, Lord. If your Lordship come to my affidavit in reply, Lordship, I have annexed the profile of office bearers of the society, Lord, at page number 49 of my affidavit in reply, Lord. Present secretary, name of the present secretary is Jogadish.
Now what has happened? He says that you have already taken the money. What else do you have to say?
No, I have
Not taken the money, but my lord, I'm planning.
From the utilization certificate, Lordship,
My lord, para 10 of my affidavit, Lordship, may come to.
Let us see it very confusing. The bill for the sanction amount of PTR
Seven
for
crore.
reimbursement was processed on demand but could not be cleared
Within the financial year.
petitioner sent letter regarding the evaluation of any second. Then no, you have sanctioned granting aid 10 lakh.
10 lakh.
Now have you paid the 10 lakh?
No, my lord, 5 lakhs already paid that part, and 2 lakh as per after deduction, my lord, 2 lakh 3,660.
What about the remaining
10 have been
2,97,000?
deducted, my lord, because due to violation of the, my lord, terms and conditions, my lord.
Violation of terms and conditions you did not pay.
No, yes.
97,000. Where is it?
Yes, my lord, para 11, my lord. Last part.
So we are entirely on paragraph number 11.
Yes, Lord.
Now what is your reply to paragraph number 11? That's the-
At page number, paragraph number 5, Lord. Page number 41.
reading the line. Yes, Mr. Counsel, it's a very difficult matter.
Lordship,
On the question of fractionalizing and all these things, whether it is to be done, whether respondent number 1 is right or respondent number 7 is right, you don't know who is right. Who is right?
I can.
One respondent says that you can fractionalize, the other says that you cannot.
Yes.
You, as per your affidavit, you cannot.
Hmm.
Now, has the respondent number 7 filed any affidavit?
No.
Who is respondent number 7?
Seven, my lord. The assistant director,
And who is respondent number 1? Secretary.
one ministry, my secretary ministry.
Ministry says that it cannot be fractionalized.
No.
How? What value does the assistant director have?
at page number 14 of my writ petition, Lordship, because
I think this is to go after the very complicated matter to be done in the last. Yes, it's the matter of the winter week. We'll see again in the just before the April vacation. The matter for admission. Yes,
Your Lordship, this matter pertains to the non-payment of the outstanding dues payable to the petitioner trust. for the operation of one-stop center in the 30 district of Assam.
What?
For the reimbursement of the dues for the operation of the one-stop center for the 30 districts of
For
Assam. For a period of 2 years in sanction.
For what? You are redirecting the state. In Yes.
I received the instructions from 15 deputy commissioners across the state. 14 of them say that the bills and vouchers, they are not proper. Certain amounts have been paid. And in one particular
Out of this
district,
4 crores and all, 2 crores 28 lakhs have been paid.
Yes, your lordship.
And remaining is 2 crores 58 lakhs.
yes, my lord, most of the reasons given by the deputy commissioners, but they say
By
that
way
they,
of an affidavit,
I'll file.
Assume Learned Council appearing on behalf of the respondent submit that she would like to file an affidavit as she has already received the instruction. List the matter again on 22nd of January 2024. The affidavit be filed by 18th of January.
Please, your lordship, the record, we have not yet received the record.
Hmm?
Yeah,
You are appealing for whom this time?
13, sorry.
Lord, the case of for sudden death due to
4 lakh.
electrocution.
4 lakh.
My lord,
No, not total.
my lord, the government had submitted the accident inquiry report wherein the negligence was attributed on part of the victim. And therefore, on the last occasion, they took time to obtain instruction whether to appeal against the accident inquiry report. So perhaps they are to submit before your lordship as to whether they would prefer an appeal or accept the accident report when they were found guilty of negligence.
What do you say?
You have to submit. You have to submit reply of the
Against what?
so
No, there's already an electrical accident report.
Yes.
So then, the only way out for you is this. Either challenge it or go it before the civil court. Ask whatever money you can. As per section
160.
regulation 5, na?
My lord, 162 of the Electricity Act.
That is okay.
yes.
But regulation 5
Yes.
categorically says that claim which you are making out here is notwithstanding your right to claim in the proper forum. Don't you think now you have to bring the electrical accident person and file a civil suit? Because this court is going to otherwise dismiss. Only way out. I've passed so many orders on this.
my lord, our senior counsel,
Huh?
our senior counsel with the R Islam turn up today for the bill held.
So,
So another time
can you make the case better? No. What to do?
because I am not thorough about the case.
You are?
I am SK Das.
You are not there. You are not a petitioner, counsel.
Yes, but he did it.
You have not signed the wakalatnama.
Okay.
Then why don't you know?
I am also not okay. I am for the last 1 month. I am in the bed for heart attack.
But now you look
Yeah.
dainty and
From last-
healthy
From last week, I
with a
came
laugh
out.
also.
From last week, I came out.
So now you should be more
Today morning, he has,
revigorated out here.
today
to do the
morning, he has
math.
informed me that he is not able to come. So I come. That's why I have not gone to the fight. I have come. I thought that make a mistake.
Okay. List the matter after the winter vacations. Did they fix a date for dismissal? On 19th of January.
19.
on which date the learned counsel appearing on behalf of the petition shall apprise this court as to whether the instant repetition can be maintained in view of the electrical accident report submitted, wherein the fault has been attributed upon the victim.
Well, electrical accident enquiry report.
Yes, Mr. Nath.
My lord, the petitioner's patta land, the public health engineering
Hmm.
department constructed a pump house, my lord, without any information to the petitioner, without acquisition of the land, my lord. So subsequently in this case, the respondent for 6 and 7, my lord, they took time from this honorable
Not
court, my
to
lord, to
be
file affidavit,
directing to
last
remove
order
the
dated.
Pump house and other structures from the portion of land. Yes,
Lordship, we have filed a affidavit, Lordship.
what is your plan?
Respond number 6, they were in possession of this land for 1995, your Lordship.
Who?
They respond number 6, your Lordship. The
Which
private.
week?
Oh, sorry.
6 and 7,
6 and 7.
Namgar, one.
One Namgar, your Lordship.
Ah.
They were in complete possession of this land for 1995, and they are the one who allotted us the land, your Lordship.
They
Now the-
had handed over the land.
They handed over land to us. Now the petitioner is saying that land doesn't belong to the private respondent, it belongs to the petitioner. So they have no right of giving the land over to us, your Lord. But it's the private respondent who gave us the land.
How?
Affidavit, your Lordship, page 3, your Lordship. I think opposition filed with department.
Affidavit filed by the respondent number 4.
Respondent number 4, your Lord.
Date. How did they give the land to you?
At the para 6, your Lordship. Department further states that a plot of land over which the petitioners are claiming right title interest has been in continuous possession of Up Nambarghag Rajawa Baba Mohta Unnayan Committee since the year 1985. The said fact is affirmed by certificate dated 1/3/2008 issued by the Circle Officer, Barama Revenue Circle. Further, the state committee has been paying land revenue with regard to the land covered by tag number and patta number so and so.
Which affidavit? Respondent number 4.
Paragraph 6, your Lordship.
It is deponent by the state the plot of land over which the petitioner has been in continuous possession. Okay. Madam, you find out whose land it as per your revenue records and file your affidavit. You are there?
For respondent of the
File your affidavit whose land it. Then only the question will be.
My-
And
Yes,
if it
yes,
is not their land, who Namghar, then obviously, but
Yes,
taking into account the affidavit filed with respondent number 4, wherein it has been mentioned that the land wherein the pump house has been set up was the land handed over by the respondent number 6 and 7. Mr. Emnath, the learned senior counsel, disputes the title, the right title and interest of the respondent number 6 and 7 in respect to the said land. Taking into account the above, this court therefore would like to be apprised by the respondent number 3, who is the district commissioner of Nalbari, as to whose land, as to whether in the revenue records the land covered by dark number 240 under KP Patta number 19 of village Okram, Moza, Nambor, Bagh belongs to the petitioner or not. The district commissioner shall also produce before this court the record of rights in respect to the said land and in whose name the said land presently stands. List the matter again. Madam, when? Where's the, tomorrow we cannot sit.
Obliged, Lord.
On 24th of January.
Obliged.
May be the
Hmm.
the exponent got to submit certain documents regarding service of the petition.
Please, your lordship, we have not received the records yet. Give us some more time so that we can produce the record.
Okay, several opportunities have been given. My only prayer for your lordship at this stage is lordship may demand back the matter.
Need the specific with whom the record should be?
Lordship, they are saying that notice was served on us.
No, understood. With whom the record should be?
Record should be with the department.
Which department? Officer?
Service tax.
Officer?
They say that lordship, the office of the lordship, response number 2, that is the joint committee.
Joint Commissioner of what?
Sorry, principal commissioner CGST lordship.
We asked him to be present. With the record. Yeah. No, I think Superintendent ADJ will be there. He will have the record with him. First, let us call him. If he can't produce, then we call the principal commissioner. Isn't it? Despite various opportunities being granted to the respondent authorities since 7/8/2023, the records have not been produced by the Standing Council of the GST Department. Under such circumstances, this court fixes the matter again on 29th of January 2024, on which date the records either be produced before this court or the superintendent, bracket ADJ, bracket closed, GST and Central Excise Commissionerate, Guwahati, be present in person at 10:15 p.m. AM. Madam, inform your people.
Yes.
Yes, Central Bank. Yes, that issue. Whether it was pending at the DRAT when you sold the land.
No, you're not. That is, there is a chronology that e-auction takes place on 27/3/2017 when we have confirmed the sale. And the sale certificate was issued on 30th of 2017. 30th of 2017.
And when was the matter pending in the DRAT?
That was filed on 1/6.
1/6/2000. So it was pending. So it will be obviously subject to outcome.
Your lordship, I may allow only one thing. That is, every action and measures has to be challenged before the DRT. And that sale certificate and the e-auction was not done. E-auction notice was done. And in that e-auction notice, they have challenged the procedure. And thereafter, they themselves have claimed the redemption.
Then go to Supreme Court against this. Why should this court entertain?
Your lordship,
This court is not this court is not sitting as an appellate court. Remember, this court is not sitting as an appellate court. This court is only sitting in the 226 jurisdiction to exercise a writ in the nature of sorcery, and there has to be an error apparent on the face. However, this court doesn't find anything. When the proceeding was pending as on the date on which you issued the sale certificate, you shouldn't have done it. You have done it, so it will be subject to the outcome of the year. And therefore, what is wrong with the order? Isn't it?
Yes, my,
That is your
yes,
submission.
my lord. Moreover, my lord, the sale has been completed on 95th day, which should be completed within 90 days as per Service Act. But they have completed it on 95th day.
Oh, it has been rightly done.
No, it's not.
Yes.
E-auction was taken on 27/3/2007.
E-action may create a right of the person in favor of you and against you. But on that basis, you cannot take away his right unless you issue the sale certificate, because the sale certificate is the mandate of the 1962 rules, isn't it? The sale certificate is issued under the 62 rules. So under such circumstances, the sale certificate having not been entered, his right is not affected. His right is only affected when the sale certificate is used. And the sale certificate, and at that point of time, the matter was subsidies. So what is wrong with that order? And that has been duly taken note of and passed. Why should this court say that there was any error in jurisdiction?
But I may allow some time for justifying. My lord, the tribunal has given 2 months time to settle the matter, but it has been pending since 2018. Yes.
See?
But for the-
Bhavat,
for the achieve that clarity, that
I'm not on that. I'm only, those technical things are for Supreme Court to decide. Because an appeal lies from there. Not here. Here
It
this
is an
court is,
appeal
oh
which we
no,
have
kindly
communicated.
appreciate. This court is only going to test on the question of issuance of a writ of certiorari against an order being passed by a tribunal.
That's appellate tribunal.
Appellate tribunal, whoever it is, I'm not concerned. Here this court is not sitting in appeal. So these minor things that every action has to be challenged and all, these are not for this court to look into. Whatever may be, the court had passed an order at a time when prior to the sale certificate has been given, you have duly intimated. Go and file a review against those orders before whatever. This is not the court.
Not that.
Huh? Cost.
Very short.
Okay.
Just on the part.
The cost will be a very short, small, 10,000 rupees. 15. And why the two matters?
My lord, second matter we have filed for releasing our
Why have you filed?
in our account. There some money has been deposited, and we have prayed for releasing those money.
Huh?
And we have also prayed before the bank also that what.
They have deposited certain money.
Yes, my lord.
Or the sale proceeds.
Yes.
Extra.
Yes, no, my lord. That the procedure should, as per the notice, the designated officer should be deposited the money in his account. But those amount has been deposited in our account.
Now,
Which-
to show that you have accepted.
Yes.
To show that the sale has been accepted by you.
Yes.
A very clever move.
Yes.
Yeah.
No, that is not our fault, my lord. As per,
Understood? Not your fault, their fault.
as per their notification, my lord.
No, they have deposited that money, the remaining sale proceeds, to you in your account.
No, my lord. All deposited money has not been deposited in our account. Some few half portion has been deposited in our
You
account.
want the remaining amount.
Yes, my lord. Both.
So if you want the remaining amount, what is wrong with the sale then?
We have approved before the bank, but they have not released those.
What is wrong with the sale then?
My lord, sale has been not.
Understood, but if you are fighting on the money, then where is the question of sale? Challenge to the sale.
Money has been deposited in our account. That money is ours money, my lord.
Understood. You want more money.
No, my lord. Which has been deposited in our account, that money.
How the money was deposited in your account? Because out of the sale?
Yes.
If it is out of the sale, the money was deposited. Your grievance is that they have not deposited the entire amount.
No, my lord, the
Yeah.
money should be deposited in the designated officer's account, that bank's account. But
Then
it has not been deposited in that particular account. It has been deposited in our account.
you don't want that money.
Yes, I want.
Again, I don't understand.
That's why I have prayed, my lord. In our prayer, my lord,
It's number 11. 10.
To release the money which is lying there in the account and so, to provide detailed transaction done by the auction bureau in the unit so. So these accounts which are there.
Yes.
These accounts belong to you.
earlier 2 accounts are belongs to me, and the appropriate account which has been notified, that is in paragraph prayer number 2, my lord. EMD remittance account. In our prayer, subpara 2.
So these are your personal amounts.
Yes, my lord.
These have nothing to do with the sale.
No, my lord.
That is what I am asking you.
Yes, my lord.
Why you are going into the designated officer and all? So this has nothing to do with the sale.
No, my lord.
And these have not been released
No,
till date.
till date.
Why?
No, your lord. Not the fact.
You have filed affidavit.
Oh.
Then should I believe what Mr. M. Sharma says?
No, your lord.
Well,
We are
we don't have that witness box to put you out there. File your affidavit. List the matter again on 19th of January 2024.
My lord, kindly fix it part at my lord.
No, pattern not necessary. See his eyes not liking it. This is the matter on 19th of January 2024. The respondent Central Bank of India is given the liberty to file the affidavit in WPC number 2545/2020 on or before 12th of January 2024. The petitioner thereupon shall be at liberty to file any reply if so advised. In respect to WPC number 5395/2018, the learned counsel for the petitioner shall duly satisfy this court as to under what circumstances, as to whether what is the effect of a sales certificate being issued during the pendency of an appeal pending before the DRAT.
Obliged, man.
40.
Yes. Anything you found out what to do and resolve the problem?
Yes, they have furnished one report card.
You are blocking. Who is blocking the area?
The waste water is coming out from my house.
Your house.
Yes.
And he is complaining.
My plot
Yes,
is
not
different.
complaint.
My
We are
plot is
saying-
Patala.
Now the water is going to your place.
No,
Yes, yes.
no,
my
but
place,
if some
my place.
other neighbors objected, filed complaint, so notice for this.
Response to the letter bearing the
I have
site
submitted
mentioned
30.
The photograph, have you seen the photograph? It seemed that they wanted to show their faces to the court rather than showing what was the actual thing.
Lordship, this report was prepared only in presence of petition. Only in presence of it. So a notice was.
Who is
served
in
to-
plot number 82?
80 plot number is my plot.
Then you are causing the problem for the culvert.
No, no, no. Kindly
Yes,
tell
but
us,
no, no.
annexure of the petitioner, culvert was at plot number 27. It is apparent from PIL order, Lordship. Kindly peruse annexure 2, page number 18. Of writ petition. This is culvert is at plot number 79 and my plot is 82. Patta land.
Here it says, as stated by Dilip Sharma so and so, the state road was proposed by state PWD for development along with a cross culvert of iron cattle
That is
Flat.
false. Lord.
just in front of plot number 82.
That is false. Lord.
But due to hindrance created by plot number 82, PWD could not provide the cross culvert on the portion of the road. It may be mentioned that the Karguli Navagar is belongs to the state where no drainage system is seen on both sides of the road.
Page number 18, Lordship.
Yes,
Writ
Mr. Nayak, what to do? Tell me. Something has
So
to be done.
Lordship,
You
it
are also
appears,
for
Lordship,
PWD. Do something.
Lordship,
PWD is not here. But anyways, do
Lordship,
something.
what their stated plot.
Hmm?
The problem that was existing in the year 2018, Lordship, it's no more there. So last line, during inspection, no overflow of the drain water has been observed.
Where is the water going?
Lordship, they are stating that the one undercross is there.
Where is the undercross? There is no mention of other.
It is not mentioned here, but one undercross is there and the water is not flowing over the road. That is what they have.
Kindly peruse page annexure 2, page number 80. And order of PIL is there.
You are challenging what?
Impute notices, but
Where is it?
page 24 and 25.
Who is Dipen Sharma?
For the brother of Dilip Sharma. Sir, brother.
Here, plot number 6 and 7.
So as of now, there is nothing.
Report.
So we close it. In view of your report, nothing. You are agree, go and do something.
Not be from
It
drainage
is
should
not
be
your
from
petition.
80.
It is not your petition.
Okay.
Now, in view of this report, which is given, that there is no overflow of rainwater as per the report. So nothing survives in respect to annexure 6A and 6B, isn't it? We close it.
It's our petition.
Huh?
Yes.
If you have
Petition
anything,
Clearing drainage system to plot number 82. And they are
Mr.
annexed in
Ali,
itself.
understood. But whenever you stand on this side, I would have heard it. But no more further hearing. Okay. The instant writ petition was filed by the petitioner. By petitioners, na?
Yes.
Challenging the notice issued by the senior medical officer, respective notices issued by the senior medical officer, Guwahati Municipal Corporation, relating to violation of the provisions of the Act, GMC Act of 1971 and the GMC bracket regulating board houses, rest houses, cafes, restaurant rooms, residential clubs and places of public recreational entertainment or resort, bracket bylaw 1976. And further, it was mentioned that the wastewater, waste coming from the pipe of the petitioner was seen overflowing in the road, causing health hazard. So, this court, by an order dated 2011-2023, directed the commissioner, GMC, as to how the problem as regards the wastewater coming from the pipeline of the petitioner could be resolved. Mr. P. Naik, the learned counsel appearing on behalf of the GMC, submits that on 21st of 20th of December 2023, in presence of various officials, an inspection was carried out. In the said inspection, amongst others, it has been mentioned that there is no overflow of rainwater has been observed. So, taking into account the above, it is apparent, therefore, that the violation which have been mentioned in the impugned communication challenge on 26 impugned communications dated 26/7/2018 no longer survives. Under such circumstances, the question of taking any further action on the basis of the said impugned notices does not arise. With the above observations, therefore, the instant writ petition stands closed. The report so submitted is kept on record and marked with the letter Y. I think that will suffice.
Action taken against the petition.
As per the impugned notice.
So, Lord, I have furnished the original copy. May I take it and furnish a photostat copy?
Absolutely no. Original is for us. Photo is for you.
Lord.
And ask your people for next time not to show their face, show their brain.
In fact, I asked the concerned person myself, Lord, why you are showing your faces
Not
that
a
way.
single photograph of the train or pipe or road.
Yes.
Only their photos with some pictures out. I've held that there was no negligence.
Problem.
From the above, it is seen that the disease with which the petitioner's daughter was inflicted upon is a very rare complication which happens on account of vaccination and the ratio being 0.8 per lakh. The opinion reveals that the respondent health department did their best with the abilities available so that the petitioner's daughter was provided the best treatment. It is also seen from the report that such rare complications following any vaccination cannot be predicted or prevented in spite of the best medical facilities. Therefore, under such circumstances, this court, on the basis of the said report, has to reach to only one conclusion, that there was no negligence on the part of the respondent health department in administering the vaccine as well as providing the treatment. In view of the above, a bigger question arises as to whether this court can grant any relief to the petitioner in the present fact that when the petitioner's daughter admittedly would require support to live a life with dignity. The report so submitted categorically mentions that the disability of the petitioner's daughter is 100% and she would require medical assistance in the form of regular medical checkup, rehabilitation programs, orthotic device support. It is also seen from the report that the petitioner's daughter cannot lead an independent life in future and would require a constant help of a caretaker. It is well established that the right to life also includes a right to live with human dignity. This court also takes note of the petition that the petitioner is a vegetable vendor and earns a meager income, and taking into account the requirements as per the report for the child of the petitioner to live a life with dignity, it would not be possible to do so without the aid of the state government. This court also finds it very apt to note that the respondent authorities during the pendency of the instant proceedings have not taken the present litigation in an adversarial manner and have provided all the necessary facilities to the petitioner's daughter so that she is in a position to get medical assistance. The affidavit filed, and more particularly in the later stages of the instant proceedings, would also show that the Health Department of the Government of Assam, as well as the National Health Mission, have shown their eagerness to provide their support for the well-being of the child of the petitioner. Reference can be made to the affidavit filed by the respondent number 2 on 25/5/2022. The respondent Social Welfare Department have also stated in their affidavit as to what possible help they can render so that the child of the petitioner can live a life with human dignity. It is also very pertinent to mention that this court does not have the expertise to know the medical needs and the intricate welfare needs of the child of the petitioner. It is the opinion of this court that the experts in medicine and humanities would be in the best position to know the actual time-to-time needs of the petitioner child. In view of the above, this court therefore disposes of the instant requisition with the following observations and directions. The daughter of the petitioner, as per the opinion rendered in the report dated so-and-so, cannot live a life independently and would require constant help of a caretaker. As of now, the daughter of the petitioner has her mother and father to look after her. But for taking care of the petitioner's daughter's daily needs, which would escalate from time to time on account of the increase in the needs and the inflation, this court is of the opinion that a reasonable amount be paid to the father of the petitioner monthly till the daughter of the petitioner attains the age of 18, and thereafter to the petitioner's daughter in her bank account or the bank account of the guardian duly appointed as per the provisions of law. This court is of the opinion that a monthly stipend would be paid as per the prevailing notification under the Minimum Wages Act 1948 issued by the Labour Welfare Department of the Government of Assam in respect to unskilled workers, and the said monthly stipend should be increased from time to time on the basis of the subsequent notifications issued by the Government of Assam in the Labour Welfare Department. Accordingly, this court therefore directs the respondent authorities, and more particularly the Commissioner and Secretary to the Government of Assam Health and Family Welfare Department, to take appropriate steps for payment of the monthly stipend at the rate as applicable to unskilled workers to the petitioner's bank account monthly till the petitioner's daughter attains the age of 18 years, and thereupon to the bank account of the petitioner's daughter or her guardian duly appointed under the provisions of law till she survives. Here I'll put one more line out there, that the petitioner's daughter, the life certificate of the petitioner daughter has to be submitted every year. That I'll just incorporate. These are all things which keeps on copying. It becomes very difficult. Yeah. To like life certificate. This court further directs the said authorities that the state monthly stipend so directed to be paid shall periodically be increased on the basis of the subsequent notification issued enhancing the wages per month of the unskilled workers. In addition to that, this court further finds that an amount of rupees 3,700 per month be paid to the petitioner in his bank account for the purpose of engaging a caretaker. This amount would be paid to the petitioner till the daughter of the petitioner attains the age of 18 years. Thereupon, the said amount be paid to the bank account of the petitioner's daughter or his or her guardian duly appointed as per the provisions of law. This court also understands that this process would take some time for due compliance, as there would be the requirement of various formalities of concurrences from various departments, which this court estimates to take around 6 months. Under such circumstances, this court directs the Commissioner and Secretary to the Government of Assam Health and Family Welfare to disburse an amount of rupees 1 lakh to the bank account of the petitioner, and thereupon ensure that within a period of 6 months, the monthly stipend along with the cost of the year is paid as directed herein above. This court further directs the Commissioner and Secretary to the Government of Assam Health and Family Welfare, as well as the Mission Director, National Health Mission, to take effective steps in consultation with the Social Welfare Department so that the child of the petitioner is evaluated at least twice a year by a pediatrician till she attains the age of 18, and by a physician after she attains the age of 18. Further to that, the said authority shall also ensure that a neurologist of the GMC provide the necessary consultation from time to time as per the needs of the child of the petitioner. The said authority shall also ensure that the medical treatment as well as the rehabilitation training which is presently being offered to the petitioner's daughter is continued so that the petitioner's daughter is in a position to live a life live a reasonably dignified life. The said authority shall also, in consultation with the Social Welfare Department, provide the authoritative device support as is required so the petitioner's daughter could achieve some degree of independent working ability. Further to that, this court also directs the respondent authorities in the health department to ensure that the petitioner is provided the support at the district early intervention center where physiotherapists and speech therapists are available free of cost. This court further directs the social welfare department to provide the necessary assistance in respect to the medical devices which would be required so that the petitioner's daughter is in a position to continue with a dignified life. In addition to above, the respondent authorities shall also provide the other assistance which are required as stated in the report and close to the additional affidavit filed by the respondent number 1 on 26/4/2022, more particularly at clauses B, C, and D, as already here quoted. You have filed an affidavit. What are the requirements? This court further directs that the respondent authorities shall periodically evaluate the health conditions of the petitioner's daughter and her welfare needs and take appropriate steps accordingly. This court further finds it relevant to observe that as this court is disposing of the instant writ petition, liberty is given to the petitioner to approach the District Legal Service Authority, Darok. If the direction herein are not complied with, the District Legal Services Authority, Darong, shall thereupon intimate the said aspect of the matter to the Secretary of State Legal Services Authority, who in turn shall inform the Registered Judicial of this court, so the matter can be thereupon placed before this court for further directions. I will also put one more thing about this what do you call? The assistance being provided by you, R.H. Chaudhary and Mr. Yeah, I will put. These are you see the amount of you keep on thinking, you get more and more things, and it is very difficult for a court to say which exactly. It is absolutely within. It's for the medical and the humanities who can very well decide what is the actual thing.
Monthly stipend.
Huh?
Monthly stipend.
Monthly stipend. Because without that she cannot survive.
Yeah.
That is, I think, the only thing. The others, as regards the medical, I will put one line out there. The authorities can, in their discretion, also decide on the question of as to how to include these medical facilities in a particular scheme, if it is possible.
Yeah.
That line I'll put it so that you have also said in B, C, and D, more particularly that these things can be put in the scheme.
But
certain things has to be left to the authorities. This court cannot have it. I'll give you some correction. Got it?
Hello, right.
So you were in bail as per 5/1/2030. Mr. PP, you think?
The only thing is, since June 2022, the case is pending for consideration of charge.
Now, if he does not appear, I'll put it. If he does not appear, the bail will be cancelled automatically by the authority. I'll make it very clear. You don't appear without further reference to this.
Yeah.
The instant application has been filed under Section 439 of the Code of Criminal Procedure 1973, praying for bail to the petition accused, namely Mohammed Qasimuddin alias Qasimuddin Khan, in connection with Sessions case number 54 oblique 2019 pending in the court of the learned session judge Kamrup at Aminga in respect to offences punishable under section 448 oblique 366 oblique 511 oblique 34 of the Indian Penal Code. From a perusal of the documents on record, it reveals that pursuant to an FIR filed on 11/4/2017, the charge sheet was filed wherein the petitioner is the petitioner, na? Wherein the petitioner was arraigned as a charge sheeted accused. Full stop. In the same charge sheet, however, it was shown that the petitioner was an absconder. The record for the during the course of the hearing, the learned counsel appearing on behalf of the petitioner had produced a certified copy of an order dated 5/1/2010 passed by the Judicial Magistrate First Class Amruk at Aminga, wherein it is seen that the petitioner was allowed to go on bail on execution of bail bond of rupees 20,000 with one surety of the same amount. Thereupon, the petitioner continued to remain on bail. Full stop. However, when the proceedings was committed to the court of the, which court? Court was committed to the court of the session judge Kamrup Aminga. The petitioner did not appear on various dates, for which a non-bailable warrant of arrest was issued against the petitioner. Thereupon, the petitioner appeared before the court. The petitioner surrendered before the court on 12th of December 2023. Isn't it?
Yes.
No. Surrendered before the court on 28/11/2023. And thereupon, upon the petitioner's appearance and surrender, the petitioner was sent to the jail Hazot. And since then, the petitioner have been in custody, in judicial custody. Full stop. It is under such circumstances the instant bail application was filed. This court, upon taking into consideration the matter in its entirety, is of the opinion that the further detention in respect to Sessions case number 54/2019 of the petitioner is not required. In view of the fact that the petitioner is not required. Accordingly, this court therefore grants the regular bail to the petitioner in Sessions case number 54/2019 on the following terms and conditions. The petitioner herein shall execute a bond of 50,000 to the satisfaction of the session judge and of the like amount to leave. To the satisfaction of the session judge Kamrup, learned session judge Kamrup Aminga. Number 2, the petitioner shall not leave the jurisdiction of the court of the session judge Kamrup Amingaon without the leave of without taking due permission. Number 3, the petitioner shall appear appear on each and every date in respect to sessions case number 54/2019 without fail. If, however, for circumstances beyond the control of the petitioner, he is not in a position to appear, his advocate, his counsel, the counsel representing the petitioner in sessions case number 54/2019 shall duly inform the learned session judge Kamrup Amingaon about the said aspect of the matter. It is further made clear that in the circumstances the petitioner violates any of the terms and conditions mentioned herein above, the instant bail so granted shall be cancelled without any further reference. With the above.
42.
Yes, now tell me. Have you rinsed it? Why? First of all, tell me. You see, in my order, there are two things.
Yes.
Not only Justice Jami's order, but also the fact that you have, pursuant to Justice Jami's order, duly complied with it and revived the OBC certificate. Have you cancelled that?
Deputy Commissioner certificate has
Huh?
This is the certificate issued by the DC. It was cancelled, but now that was again.
So that is why, these are the two reasons. Now, have you cancelled that?
No.
So as of now, Justice Jami's judgment is there. Number 2 is that certificate still survives. In spite of now you have got various information.
Yes.
So these two circumstances being already there, can it be said it will come within the ambit of subsequent event unless you do something with these two?
But in fact, after having this all this development, the learned single judge judgment which was passed on 24/11/22, that has been ultimately upheld by the on March 6.
That's okay.
That's we have preferred a review petition for the
Review is okay. Whatever may be, review only notice has been issued.
Notice has been issued and notified.
There is not even a stay.
Stay is to be considered a piece of judgment.
Whatever may be, the stay, even if it is given, just for example, the stay, if it is given, it would not stay Justice Jami's judgment. The stay, although it may, by the principles of what you call merger, this order merge with that. But the stay of the judgment would only revive at best the effect of the year. But the order of Justice Jami continues to remain unless it is not being set aside by a court. So under such circumstances, when these two things are there, where is the question of seeking a review?
So at this stage, but we also cannot file a review petition of that 24/11/23.
No, you cannot, but you can ask for set aside.
Yes. If we succeed in the review petition, if they repeat, ultimately the repeat will be hard and accordingly we will apply for the kind of the. So at this stage, as that this petition is sure, not at this stage. The possibility to the liberty and they have to take.
Sure. The instant review application has been filed by the petitioner, by the review petitioner. seeking review of the judgment and order dated 17/2/2023 passed by this court in WPC number 482/2023. It is well settled that for the purpose of reviewing a judgment and order, the principles as laid down in section 114 of the Code of Criminal Civil Procedure 1908, read with order 47 rule, or order 47 has to be applied into. The principles on which a review can be entertained are: number one, there is an error apparent on the face of the record. Number two, discovery of new facts which was not within the knowledge of the authorities at the time when the judgment was delivered. Number three, for any other sufficient cause. As regards the condition number 1 and 2, the law is well settled and would require no deliberation. But as regards the condition number 3, it has been all along settled that the said conditions of other sufficient causes has to be read into on the basis of the condition number 1 and 2. This court have also taken note of the judgment passed by this court on 17/2/2023, which has been sought to be reviewed. A perusal of the said judgment reveals that the petitioner herein was suspended in view of a recommendation being made by the state level scrutiny committee for cancellation of the petitioner's the respondent herein, who was the petitioner in WPC number so and so, was suspended. In view of the recommendation of the state level scrutiny committee, who recommended the cancellation of the petitioner's OBC certificate by an order dated 26/2/2021. In the meantime, prior to the filing of the writ petition, that is WPC number 6282/2023, the said recommendation which was made in the meantime, prior to the filing of the, on the basis of the state level scrutiny committee's recommendation, the petitioner's OBC certificate was also cancelled. This recommendation made by the state level scrutiny committee, as well as the consequential action of cancellation of the OBC certificate of the petitioner was put to challenge in WPC number 2286/2021 by the order dated by the order passed by the coordinate bench of this court. The order dated 24 the order dated 26/2/2021 passed by the state level scrutiny committee, as well as the consequential actions were set aside. It is also relevant to take note of that pursuant to the setting aside of the order dated 26/2/2021 of the state level scrutiny committee, as well as the consequential actions, the OBC certificate of the petitioner therein was restored. It is under such perspective that the petitioners have filed a writ petition. The petitioner therein had filed the writ petition being WPC number 682/2023, challenging the continuation of the suspension order on the ground that nothing further survives. On the ground that the continuation, challenging the continuation of the suspension order on the ground that the same was being continued without any justifiable reasons. This court had also taken note of the submissions so made in the said writ proceedings, wherein it was submitted that the government had duly accepted the order dated 24/11/2022 passed by this court in WPC number 2286/2021. Inasmuch as the Deputy Commissioner Jorhat, pursuant to the said order, had revoked the prior cancellation of the OBC certificate of the petitioner by an order dated 28/12/2022. Taking into account the above, this court, finding that there was no justifiable reasons to continue the suspension, as the petitioner's OBC certificate was restored, had revoked the suspension order dated 12/3/2021, and directed forthwith reinstatement. It is further relevant to take note of that this order, that the order passed by the coordinate bench of this court on 24/11/2022 in WPC number 2286/2021, whereby the inquiry report dated 3/10/2019, the speaking order dated 26/2/2021 were set aside and quashed, was put to challenge before the division bench of this court in writ appeal number 42/2023. The division bench of this court, by the judgment and order dated 1/6/2023, after perusing the materials on record, including those documents which were also produced by the state of Assam in the said proceedings, as could be seen from paragraph number 6 of the order passed, judgment passed by the division bench, confirmed the judgment of the learned single of this coordinate bench in quashing the speaking order dated 26/2/2021, passed by the state level scrutiny committee, and affirming the social status of the respondent number 1 as OBC Kuch. OBC bracket Kuch. The record further reveals that pursuant thereto, there were certain other inquiries being carried out, and on the basis thereof, it is now the opinion of the state government that the information which was provided on the basis of which the state government had accepted the materials, accepted the doc. No, it is further seen from the records that as per the state government, upon further inquiry, could come to learn that there were certain reports which were furnished to the state government which were not accurate. And as such, there is a requirement of taking a relook into the evidence as to whether the petitioner here, the respondent herein, who is the petitioner in WPC number 682/2023, it belongs to the OBC category or not. It is also seen that on the basis of such inquiry being conducted, and a review petition was filed before the division bench of this court seeking review of the order dated 1/6/2023 in writ appeal number 42/2023, along with an application for condonation of delay in preparing the said review petition. Yes, Mr. Nath, why you need condonation of delay in a review petition?
It was objected by that is why.
But here they have not.
No. Here they have. If we filed a review petition, they raised an objection. In fact, they note sheet they have completed 165 days, and they insisted us to file an application. We prepared and filed. And while moving this petition, it was from the court. That is why on court has put it both the.
The said review petition was registered and numbered as? You have number?
No, I has been numbered.
Okay.
The review
Yeah.
number.
However, it is also relevant to mention that on 15/12/2023, the division bench of this court had condoned the delay in filing the review application and fixed the review application for consideration and directed listing of the review application on when?
Five.
On 5/1/2024 for consideration.
Effect clause 61.
It is also further relevant to take note of that in the meantime, the respondent herein, who was the petitioner in WPC number 682/2023, had also filed a contempt proceedings, initiated a contempt proceedings against the Secretary to the Government of Assam Personnel A Department against one Tanmoy Pratim Borgohain, Secretary to the Government of Assam Personnel A Department, which was registered and numbered as con case C number 260/2023. In the said proceedings, it is also seen that the courted bench of this court have drawn contempt against the said respondent in the said proceedings. And by an order dated 18/12/2023, and directed the said respondent to show cause as to why punishment permissible under law should not be awarded upon him for committing contempt of the court's order dated 17/12/2023 passed in WPC number 682/2023. The case thereupon, the said contempt proceedings thereupon was fixed on 21/12/2023. You have filed an appeal against this contempt
Yes,
case.
yes.
What happened? What is the number?
Contempt appeal number 2 of 23.
The learned counsel appearing on behalf of the review petitioner submits that against this order dated 18/12/2023, passed in con case number 260/2023, a contempt appeal being contempt appeal number 2/2023 was filed before the division bench of this court. What happened?
It is 3.4 of
Wherein the matter is fixed on 4th of January 2023 for further consideration. In the backdrop of the above facts, let this court therefore consider the submission of Mr. D. Nath, the learned senior government advocate. The learned senior government advocate submits that in view of the certain disclosure, certain materials coming into light, which would indicate that the petitioner OBC certificate was rightly cancelled, and the same being not present, available at the time when the judgment was passed in WPC number 2286/2021 on 24/11/2022, or even during the proceedings in writ appeal number 42/2023. A case has been made out for seeking review of the order passed by this court. A review of the judgment passed by this court on 17/2/2023 in WPC number 8682/2023. Anything else? That is it, no?
We said that the inquiry was not
No, these came into light later on. That is it.
later on. Page 53 is the paper that
Upon hearing the learned counsel for the review petitioner, it is the opinion of this court that the said materials which have been on the basis of which the petitioner seeks to review the judgment passed by this court on 17/2/2023 in WPC number 682/2023. Are not relevant it is the upon hearing the learned counsel for the it is the opinion of this court that the materials on the basis of which the review petitioner claims that this is that the judgment passed by this court dated 17/2/2023 in WPC number 682/2023 is required to be reviewed is totally misconceived. Inasmuch as the said materials, inasmuch as the judgment which was rendered on 17/2/2023 was rendered on two basic aspects, was rendered taking into account two aspects. First, the judgment passed by the coordinate bench on 24/11/2022 in WPC number 2286/2021, whereby the inquiry report dated 3/10/2019 and the speaking order dated 26/2/2021 issued by the state level scrutiny committee against the petitioner was set aside. The second aspect pertains to that on the basis of the said order passed by the coordinate bench dated 24/11/2022 in WPC number 2286/2021, the government duly accepted the same and revoked the cancellation of the OBC certificate. Full stop. These two aspects still continue to hold the field, inasmuch as the judgment passed by the coordinate bench on 24/11/2022 in WPC number 2286/2021 had only further was confirmed by the division bench of this court, thereby further cementing the law, cementing the findings and observations made by the coordinate bench in its order dated 24/11/2021. First, this court have also put a specific query upon Mr. D. Nath, the learned senior government advocate, as to whether the even after getting informations, any further inquiry has been done for the purpose of cancellation of the of OBC certificate of the petitioner, of the respondent herein. The learned counsel submits that no steps for cancellation.
Inquiry is going on, cancellation of it.
He further he submitted that only a process had been initiated, but the OBC certificate still holds the field. Under such circumstances, it is the opinion of this court that unless and until these two very aspects of the matter is not eroded by either by the order, either by seeking review of the judgment passed by the division bench in read appeal number 42/2021-23, as well as without cancellation of the OBC certificate, there arises no grounds for review of the judgment passed by this court on 17/2/2023 in WPC number 682/2023. Under such circumstances, this court therefore dismisses the instant review application as premature. The order is enough indication what to do.
Item 14, order.
Liberty
Is premature at this stage. At this stage, I can.
all order.
14, order.
But you don't require a liberty for reviewing this because of the fact that the indication is enough what to be done if you want. But if you don't do it, that's that. But I think, Mr. Nath, whatever may be, there is an order passed by this court for directing you to forfeit. Don't make this court lose the confidence upon the government that they are not going to do all this. We will become more harsher. Because if you see on otherwise also, yes, you reinstate and thereupon you do whatever may be. Thereupon you again disciplinary proceedings. I know why you are not initiating disciplinary proceedings. The moment you initiate disciplinary proceedings, you will be you want to terminate his service on the ground of fraud. No, that is the reason why. Because the moment you initiate disciplinary proceedings, then it will go under the discipline and appeal rules, and he will be then you cannot later on take the recourse to the fraud and terminate him in limine.
If the inquiry is not that an observing
But would heavens been fall if you have just complied with the order passed by this court? Yes, you can very well take it. But is it necessary for all these litigations for even doing him suspended, just reinstating the order passed by order passed by this court, and thereupon you take up whatever action? Why you are not doing that? Because this does not clearly, goodly, nicely reflect. You are fighting all litigation. You are fighting a litigation in contempt. You are fighting there in the division bench, not 1, 2 litigations out there. And you see, you have affidavits on oath, which will make it more worse time and again. And this is going to only delay it. Yes, you may be at a later stage, but one fine day, this matter will go this way or that way. I think the best option is to comply and thereafter do whatever you feel like. Finish everything. Okay. Yes, what is this?
earlier occasion where the petitioner was not present.
Oh, yes. So, one. Okay. None appears on behalf of the petitioner on call. On the earlier occasions also, the petitioner had not appeared, but that steps was also not taken, for which the instant petition stands dismissed for non-proceeding.
15,
Okay, take care of that. Mr. Nandini. Yes, CBI.
Lordship, petitioner was absent on the last call, Lordship.
Huh?
Petitioner was absent, Lordship.
Understood.
With
Why were
time-
you not present yesterday in another matter?
I
You are
was
not
in-
the CBI.
Lordship, I was in late, Lordship. Court number
Then
50.
ask CBI to have more counsel.
Process
Court
going on.
couldn't do anything yesterday in that matter. We were looking for the CBI. And also Mr. B. Gogoi. Both of you are not there. For
Was
which
on
the
late,
matter could not be brought to a logical conclusion. These people were expecting something will happen.
I'm sorry, Lordship.
I said that there was to show B. Gogoi's name and everybody said Mr. B. Gogoi's name due to pictures on.
P. Gogoi, Lordship, PPP Gogoi.
Oh, that BB Gogoi. No. CBI was there and
P. Gogoi, Lordship, that PP.
yes,
APP.
that person.
Yes. PP, Lord. APP.
He was not there.
He was not present. Prior, he was in other court.
I thought it is you.
Oh, Lord. Status report was called for, but
Huh?
status report of that case has been called for, Lordship.
Yes.
That P. Gogoi was very active. He was not present because I heard, Lordship, yesterday in 15 courts, Lordship, criminal cases were going on. So all the PPs were occupied in those courts.
Oh, so I didn't have bail matters, so this is. Anyways, where is the petitioner?
Petitioner was absent, Lordship, and notice was served.
Huh?
The office note. Notice to the petitioners were served, Lordship.
No,
CBI will file a
no,
petition.
earlier the petitioner appeared.
Three petitioners are there, Lordship.
Huh?
Three petitioners are there.
Ah.
There are total three petitioners. Petition number 3, advocate for the petition number 3 appeared on the last.
40?
3.
What is this? 3. Okay, we'll have it. Done appears on behalf of the petitioner on call. This is what? Challenging some FIR?
Yes, Lordship.
What is he asking for?
They are asking for CBI investigation. Lordship. Already we have filed affidavit stating that we have already carried out investigation.
Has it done?
Facts are same. Cases are different, Lordship. Here in this case, Lordship, they filed the FIR in Karimganj, Lordship. Prior to that, we have taken up a investigation, 2 photo, Lordship, on joint surprise checking, Lordship. And we registered a case. There the petitioners were on it. They are the accused in that. So they are now not willing to say that.
That is why they are not here.
Arrest, Lordship. They are accused. They, by the help of custom officials, they are.
So in respect to these 3 PS cases,
Yes, Lord.
there is already a.
No, not these PS cases. Prior to that, prior to
No,
lodging of
in
these.
respect to the incident,
Yes, Lord.
you have already investigated,
Yes.
wherein actually the petitioners are the first.
Accused. There are some of the.
They are some of the.
Some of-
And madam, for whom you are?
So the respondent of 15, 20, 25.
What do you have to say?
Here the accused persons in the stated FIR. The petitioners have added that they are the Christians who have conducted illegal.
Anyways,
Post
what is the government doing as regards this? Did we call for anything out here?
No, Lord. Affidavit has been filed by CPI and the private respondent. I think Lordship, the
Office note of
Union of India has
Wait,
also-
service.
Union of-
Okay. So as of now, there is no petitioner counsel.
Okay. Notices were also.
None appears on behalf of the petitioner on call when a matter has been listed. On the other hand, Mr. M. Haloi, the learned standing counsel for the CBI, submits that in respect to the incident, in respect to the offense, the commission of offense as alleged in the 3 FIR, the CBI had already investigated the same and have found that the petitioners herein where the persons were amongst the accused persons. It is also seen that thereupon, pursuant to the filing of the affidavit in opposition, the petitioners have not engaged any other counsel, despite the fact that the earlier counsels have.
Petition number 3 has engaged one counsel after filing of the petition number 3. But they didn't.
The petitioner number 1 and 2 have not engaged any other counsel, wherein one M.K. Sharma was engaged as the counsel for the. Oh, Mr. Khan, you are there. You are the person who were there. Then did you hand over the brief? And I took it. Was engaged as a counsel. He had also not appeared in the matter today. Further to that, no steps have also been taken.
Notices were served.
Under such circumstances, this court, for the interest of justice, adjourns the matter for the day to be listed again on 12th of January 2024. It is made clear that if the petitioner is not represented on the next date, the instant petition shall be dismissed for non-prosecution.
May I pray to fix the date after?
What?
Fixing date, Lord.
12th, I said.
It will be on 16th.
Why?
On 12th, already matters were
Huh?
On 12th, already some matters were taken.
12.
Yes.
You don't be there. You show your face in the video conference. Yeah. I'll finish. Yes, what is this? So many councils. I was just thinking I almost finished up the list. Why there are so many councils sitting out there? Board of Cricket. Yes. Oh, this matter. Now tell me. Now I am taking bench 4, bench 5. Now tell me, I can take up this matter. Now tell me. You don't have a case. Why?
In item number 17, they have filed an IA
Who?
for the
No, forget about that. First, you show your maintainability of filing the writ petition against the CCI or the ACA. PCCI, okay. ACA, how? ACA, certain dues are to be paid. You were supposed to satisfy. You left out there on the last occasion saying that this matter does not pertain to this court because I am taking up bench 4. I was taking bench 5 with the bench 4 matter. Now this court has the jurisdiction to take bench 4 and bench 5 as God has it. Now you explain to me. Yes, tell me. No, I am going to dismiss it. Forget about orders. I'm not concerned. Show me. Now I have the jurisdiction. Don't think I am not concerned. I've already heard the matter. I put a specific question to you as to how a writ would be maintainable against ACA for contractor. Then I think better off I dismiss you, go to Supreme Court. Supreme Court judgment is for Supreme Court to. All these matters against this.
This matter would be appeared by their counsel.
So what? Let the senior counsel be appearing now. I'm coming in 5 minutes or the matter goes.
No, Lordship, it's
Sorry.
about conduct the category operation.
So what? Senior counsels are daily wages. What do you mean to say? The matter cannot. Are you saying that the senior counsel out here has personal is an advocate on record? No. He cannot have a personal. He cannot have be personal to a brief. That's the ethics of a senior counsel. Are you saying that this particular senior counsel doesn't have the ethics? I know this senior counsel, he has the ethics. Don't, for a case, spoil his reputation. You argue the matter now. How do you maintain this writ against ACA?
All pleadings are complete.
So what? I don't need pleading. I need a simple answer to a simple question. How do you maintain the writ against it? This court is not going to sit out here. You have any amount, go before the civil court, not before it.
But if PIL is maintainable against SCA, why not if repetition is not maintainable?
For?
PIL is maintainable.
PIL for what?
In the election process, there was a PIL.
For what? Why?
Impugning notices.
No. Let me tell you one. Would a PIL be maintainable in respect of a private school amongst the dues to be paid by the private school? No. But the moment the private school does anything which has a relation of public nature, then in that case it would be a PIL will be a PIL or what, a writ will be maintainable.
Yes, but
That is why a Don Bosco against Don Bosco, a writ will be maintainable if there is an infraction of the public duties. But otherwise, a teacher out there in Don Bosco cannot initiate a writ that the Don Bosco school is not making payment. This is the same way. This is, you are a contract. You did some work for the ACA. That's for the civil court to discuss.
Lordship, here also we are making public stadiums. Lordship.
So
This is
what?
complete and international
what?
matches are going on. Lordship.
So what?
They are not paying
How
out.
does it matter if you are making public? You are not doing any public function.
After the APL matter, Lordship, writ is maintainable on contractual.
So that is a very good case for putting it in the division bench. That is why I am dismissing it. This point of law needs to be settled out there in the division.
Lordship, for today, Lordship will not take
No.
Lordship will fix any
Today you cannot escape because last time you said that. Oh yeah, where is that order? Need that order. Who is the petition?
That was another case.
Another case? One more?
There's one Western out road.
Oh, now no, now too he cannot run away. I'm taking bench 4, bench 5.
I have not prepared that way, but therefore, because today was the application file, this matter was a
I'm not
different
concerned
matter.
about those
It
applications.
is fixed on an order column.
So what? You satisfy this court. How are you maintaining this writ?
But in the PIL also, Lordship, your Lordship was appearing there, Lordship. What I see, Lordship, may not like take up this matter. I am just pointing it out. Lordship.
I draw contempt against you now. I'm drawing contempt against you. I'll ask the police to immediately arrest you and put. Then you don't even have a division bench.
I'd argue.
Don't make this take of statement. You know the division bench judgment out there, the Supreme Court Constitution bench. I know where to recuse. It is absolutely within me.
Yes, that's right.
And that was an ACA election which was happened. Does it mean for all times to come, I cannot take up any matters pertaining to ACA or even the BCCI for whom I have represented? Are you saying that when I am appearing for Election Commission of India, I cannot take up any Election Commission of India matters? Then don't make this stuff. How many years of practice do you have? How many years of practice do you have? Tell me.
12 years.
Then this basic thing you don't know. Have you read the judgment of Indore, what do you call it, Indore Municipal Board? Have you read that? That's been the judgment of Justice Arun Mishra. In fact, this is contempt.
Sorry.
Don't point out. I know what is there. Are you making an allegation that I am taking up because of vested interest?
No, no.
You make an allegation, then I'm putting it out there.
No, no. Not at all, not. I just,
Why do you have to point out that? Argue. First on maintainability.
Yes. That if there is a judgment, but the judgment is quoted in the in the judgment of Palika Vidya versus Asa reversible. It was in a private unaided school also. There also it was maintainable.
Absolutely. I'm therefore saying it's against ACA the maintainable, the moment it will maintainable tomorrow. Just for example, in Borsapara Stadium, something goes wrong. It is under ACA. In Borsapara Stadium, something goes wrong. It is under ACA. Therefore, if something happens to the public, obviously a writ can be maintained.
Yes, sir.
And in those cases, in all these cases, this is all as regards public discharge of public duties. Is payment of contractual bill to you is a discharge of public duties.
I'll place an affidavit, additional affidavit that I had filed 19 August 2021 in my matter relating to 4834 2020, wherein when ACA has filed an agreement with us saying that my bills are pending for page number 15.
No, this matter is not there. Why are we concerned with 4384? We are concerned with the other three. In these cases, SCA is there.
Yes, SCA is there.
Where? In 4384. 4384, there is no SCA. This is some pension dues. Where all the parties are Commissioner here, Director of Pension, Additional here, Director of Accountant General, Madam, District Administrative, Primary Education.
In 4834, the affidavit was filed. Item
484 is different here.
19.
Yes.
Now, BCCI is a state lordship, though not a state. State lordship, BCCI was doing public function, therefore it was maintainable. There is some judgment holding that.
For what purpose? In respect to contractual bid? That BCCI judgment is different because what they were doing out there in the telefilms in the BCCI, that judgment is on a different line. Why they were held to be a state?
Contractual bids also.
Show me one judgment. No, show me one judgment in respect of other authorities like these. They even don't come within the ambit of a state. BCCI doesn't come within the ambit of a state.
But public function they are doing their.
And as such, as they do public functions, can you maintain a REIT as regards contractual due? No.
But if the 226 has for fundamental rights, legal rights, and any other purpose, it may
No. Fundamental rights and constitutional.
Fundamental rights, constitutional rights, and any other purpose.
Any other purpose? Where do you get it?
The definition itself.
What does it say? Any other purpose? Then why don't we close down the civil court, the arbitration? Nothing is required.
It is that bills were for a contractual for a public stadium, mix of a public
So what?
stadium.
Public stadium,
Public money
tomorrow,
is involved.
tomorrow, just for example, you personally hold a big Durga Puja Maidan, and then tomorrow a rate will be maintainable because the public is going to visit there.
Public money is involved.
Public money? Why is the public money? ACS is public money. You pay any amount to the ACA, or you buy tickets for that. That is the public money.
We buy tickets.
The construction is done because of your money. Yes. I don't have any CAV. This is a good. But this is such a clear case also. The question of making it a CAV also, people will laugh.
But if would take this matter, I'll come prepared on this issue, but we'll have to not fix any data. I'll place, I may, Lordship may dismiss the petition, but I'll just place the judge.
Which judge?
I'll look into the.
Okay. We opened the year with on third. On third, we are having it at the first item in the day. The first item in the day would be
Lordship, I'm
dismissed.
really very sorry.
No, Mr. Counsel, you have made a very mistake. Don't try to antagonize the court. You have to have 12 years of mistake here. Merely because of a client pays you, you should not spoil your reputation in the court. And you have done so. Earlier, you shouldn't have. Do you know this court sets out here not on the basis of whatever matter it comes. We take up these matters on the basis of the authority. Have you seen the list?
I'm sorry.
Who creates the roster? Tell me. Who creates the roster? The chief. Now, have you seen the list? On top of it, on the top of it is given under the authority of the Chief Justice. Meaning that all the matters, irrespective of the bench which area is there, I can take it up. And you make these type of submissions. And today you have made a submission to the effect that I cannot take it up because I have appeared for ACA.
No, Lord. No,
I have also appeared for the ACB on the last earlier, APDCL. But then also you didn't say then that a matter I shouldn't be taken up. Black no, green no, black no, red book of the And what is this IS for?
I filed for striking on for
Who are you?
PCCA because the contract was between ACA and the
No, he is making BCCI just to bring the gist and
yes,
everything.
yes,
No, Lord, in the rejoinder, in our matters also, such application was filed. In the rejoinder, Lordship, the BCCI have put it on affidavit that the infrastructure subsidy is given by BCCI. 50%.
Understood. But is BCCI taking your money or any public money? No. It is a society. The same like the ICA is a society. You should know the basic aspects by which you file a writ petition. You don't file a writ petition just for the sake of filing a writ petition because the client has come and given you money, you just file it. These are matters which should be taken. Tomorrow, in these cases, these are of 2021. Do you know that the moment it is dismissed, even in a writ proceedings, we sometimes pass an order out there, but otherwise you are not entitled to limitation or the benefit of limitation under Section 14. If you are not benefit of limitation, then what will happen to your client? Do you know all these things? For you to do the matter and get this court will at best, what order can this court pass at best? Ask them to verify and make your payment.
Yes,
That's all.
that only.
Why? Then If they, the moment they dispute one thing, that they are not entitled to matter finishes.
But if they have not disputed till now,
No.
we have already.
Then, once they have disputed on that basis, this petition can be dismissed without even going into the question of maintainability.
We will see the affidavit then. But
They have disputed? Yes, we believe it.
no, one affidavit is filed on maintainability and second affidavit was filed relating to the seizure of all the documents. Two affidavits are only filed.
There is nothing on record that purpose, no matter.
Lot and order was there.
List the matter on third. Now, upon hearing the matter at length, the learned counsel appearing on behalf of the petitioner sought for a further opportunity to satisfy this court on the maintainability of the petition. Inasmuch as to whether a writ would be maintainable against the Assam Cricket Association. A final opportunity is given to the petitioner. Satisfy this court on 3rd of August, 3rd of January 2024. List the matter immediately after the motions. So